context.
Jeff, to the form of the question, Your Honor, that's a decision for this court to make.
I'm sustaining. Go ahead and rephrase, please.
It's whenever we're looking at text messages, the text messages don't say the context within which they were texted, correct?
I'm sorry, I don't understand the question. I apologize.
I think it's a bad question, and that's my fault.
Okay.
I'm going to move on.
Okay.
Exhibit 23 continues to be messages between Ethan and his mother. Do you recall admitting those, or providing those to the prosecution and them being admitted as Exhibit 23?
I believe I do. If I can just look at it real quick. Thank you. Okay, I remember these. Yes, ma'am.
Okay.
Yes, ma'am.
And these text messages mostly start off with Ethan.
See, I thought this was from earlier. I can't find the second half. This is all they're playing. So I'm like, well, where is the second half? Because I can't find it anywhere. I'll look again. Hold on. Oh, you did? All right.
Mr. Connell, again, that video was from November 27, 2021.
That's correct.
Okay. Thank you. Nothing further. Any approach for the conduct?
Sorry, I wanted to see what this was. Is that her? So, entertain me. This is her and him at a shooting range? And she's teaching him gun safety? Or he's teaching her how to shoot a gun? That's Ethan, though, right? Not the dad. So he's putting it away correctly. Okay, kid did nothing wrong at that point.
Crumbley shooting down at your shooting range, correct?
That is correct.
No further questions, Your Honor.
Any questions on behalf of Jennifer?
No, thank you, Judge.
Any regret?
Just very briefly, Mr. Connell, what does someone need to do to bring a minor into the shooting range to shoot?
They just have to fill out our waiver form as a parent or guardian with the minor's information.
Okay, and that's what Jennifer Crumbley did on November the 27th of 21?
As far as I know, yes.
Okay, so if they would have been at the range in prior months, like counsel just asked, they would have each time filled out a waiver and asserted that there are that minor's parent or guardian and they are with that person.
Well, we would have had it on file and we would have selected that information in our system.
Right, because it's illegal for a 15-year-old just to show up and shoot on their own, right?
That is correct.
Right, okay, nothing further.
I just have one follow-up question. You were talking about the waiver that was filled out. In this case, the waiver was actually filled out by Dad, months prior to Jennifer Crumbley coming in. Is that correct?
The waiver, I believe so.
Okay,
believe
I
that.
just wanted to verify, on that day, Jennifer did not fill out a waiver, but there was one on file.
I don't know, unfortunately, when her waiver form was filled out. I don't have that information.
Okay, thank you.
You may step down.
Thank you.
Any others want to witness can't be excused?
Not for the people, thank you.
No, Judge.
No, Your Honor. How your next witness?
Thank you. People called Detective Adam Stoyek. Judge, may counsel I approach, I have some changes to our exhibit list.
That's a small courtroom.
I do have one quick question. I know it's really that you asked. We have some objections to some of the legal facts. Oh, you might have, okay. My notes are received.
Sir, please raise your right hand. You solemnly swear in the testimony you're going to give will be the truth under the penalty of perjury?
I do.
Have a seat, please. Please state and spell both the first and last name for the record.
Adam Stoyek, ADAMSTOYEK.
T.O.
YEK.
Okay, I'm going to ask you to keep your voice up as loud as possible. As you know, we do have microphones in front of you. One does record, one does amplify. It is necessary for us all to be able to hear what you're saying at all times, okay?
Okay.
Thank you, Judge. I'm going to do my best with the projector. Oh, there we go. May I proceed, Judge? Sir, what is your occupation?
Detective with the Oakland County Sheriff's Office.
And how long have you been a detective with the Oakland County Sheriff's Office?
2 years.
What's your current, where's your current assignment at? What substation?
The Pontiac substation.
Pontiac, okay. And you've been in the Pontiac DB, the detective bureau, the whole time you've been a detective?
Yes, sir.
Okay. And how long have you been an officer with or sheriff's deputy with the Oakland County Sheriff's Office?
Just under 10 years.
Now, I want to direct your attention to November the 30th, 2021. Were you working that day?
I was.
Were you made aware of the Oxford High School shooting while you were working?
I was.
Okay. And what did you do when you were made aware of that information?
My partner and I got into our county issued vehicle and went to the Oxford High School.
Okay.
I apologize, all I can hear is like the humming of maybe the projector. Could the witness keep his voice up a little?
Sure.
Please, this. You just keep your voice up as loud as possible.
Okay, so November 30th, 2021, you were working that day
I was.
and you were made aware of the shooting at the Oxford High School.
I was.
And did you respond to the school?
I did.
Okay, you said with a partner?
Yes.
And who's that?
Detective McPherson.
And tell me, please, what did you do when you first responded?
We assisted with the initial search of the high school. After that, we assisted with escorting students out of the high school.
At some point, were you tasked with securing the residence of 112 East in Oxford?
Correct.
And did you go to that address?
I did.
And tell us what's at that actual address. Was it a condo, a single family home, or something else?
A single family home.
If you could tell us a little bit about the layout of the home. Well, first, may I approach?
Yes.
This is People's Proposed 42. Sir, what have I just handed you?
Looks like a layout of 112 East Street.
Okay. And does that correspond with what your actual memory is when you were there at 112 East Street?
Correct.
Okay, people move to MIT 42.
Any objection?
No objection.
No objection, Your Honor. You're admitted.
Okay, and you can see it's on the screen here displayed. You can refer to the exhibit I've handed you if it's easier for you
Okay.
to know. Tell me, please, what the layout of this residence is.
You walked in, there was a living room, a small dining room. From there, you'd walk into a kitchen. Right off the kitchen, there was 2 bedrooms, kind of close in distance. After that, you walk into a hallway. There was a washer dryer machine. And after that, the furthest west side of the house was the master bedroom. And off the master bedroom was a stairwell to the basement.
Okay. Now, Detective, I used the word secure. Would that be right? You were there to secure the home?
Correct.
And now, was that pending issuance of a search warrant?
Correct.
And was the search warrant actually obtained to search that residence?
It was.
When it was obtained, did you participate in the search?
I did.
Now, is a residence typically secured prior to the issuance of a search warrant?
It is.
And tell me why.
To preserve any evidence that may be inside of the residence, and just to ensure that nobody goes inside or outside of the residence that's not supposed to.
Okay, so you need to protect the integrity of what's inside the location, is that right?
Correct.
Okay. And you did that?
I did.
But nothing's actually searched prior to the search warrant, am I right?
Correct.
Okay. Now, in your preliminary securing of the residence, did you observe anything in plain view? Anything of note?
Yes, I did.
Okay, tell me what you saw.
Inside of the master bedroom, there was a open handgun box on the bed. Next to the handgun box, there was a empty box of 9mm ammunition on the bed as well.
May I approach witness?
Yes.
This is People's Proposed 43. Sir, this is a photograph. What is that photograph of?
That's of the handgun box and the empty box of ammunition that was on the bed.
Okay, does that photograph fairly and accurately depict what you observed November 30, 2021?
It does.
People moved to MIT 43.
Any objection? No objection, Your Honor. You're admitted.
Okay, so is this the photograph that screen?
Yes.
Okay, so this case that's open, what did you describe that as?
Handgun case.
Okay, now is that a plastic case?
Yes.
Now there's clasps on there to close it, am I right?
Correct.
Okay, is there any other locking mechanism on there?
Nothing that I observed, no.
Okay, and what's the red box next to it?
It was an empty box of 9mm ammunition.
Did you see either James or Jennifer Crumbley while you were there on scene?
I did.
Did you see both of them?
I did.
Can you please point them today and describe something they're wearing today.
James is wearing the orange jumpsuit. Jennifer's wearing the black and white jumpsuit.
You know, would record reflect identification of both defendants?
Any objection? No objection. No objection, Your Honor.
Now, at some point in time, were you given a code for a gun case that did lock?
I was.
Okay, and who provided that information?
James Crumbley did.
And what was the actual code? What was the number?
000.
So once the warrant was officially authorized, you participated in the search as well?
Correct.
Now, I want to start back at that same bedroom where you made this observation here in 43. May I approach witness, Judge?
Yes.
Sir, I'm going to hand you a couple at once. I'm approaching with what's been marked as people's proposed 46, 47, and 48. 46 is on top.
Okay.
All photographs.
All photographs, thank you. Starting with 46, sir, what have I handed you?
46 looks like it's the dresser in the master bedroom. The
Is
TV
that the
on it.
same bedroom where you made this observation with the open gun case and ammo box?
Yes,
And is that photograph? Actually, take a look at all 46, 47, 48. Tell me if those photographs fairly and accurately depict what you observed on November 30, 2021.
they do.
People moved to admit 46, 47, 48.
Any objection? No, Your Honor. No objection. The evidence.
Okay, thank you. Starting first with 46. Now you said this is the same bedroom where you found the empty gun case?
Correct.
Okay. And we're looking at a TV with a dresser drawers.
Yes.
Now, do any of these drawers themselves lock?
Not that I saw, no.
Okay. And did you have occasion to open up the far right drawer?
Yes.
Okay. Was this photograph here? This is 47. Does this depict what you observed when you opened that up?
Yes.
Okay. And what were you looking at here?
It's a handheld gun safe.
And on the top of it, I see some kind of dial. What is that?
That's the combination for the lock.
Okay. And did you use 000?
Yes,
And did it open?
it did.
And when you opened it, this is 48 here. What did you find?
It was a 22 Derringer and a 22 caliber Kel-Tec handgun.
Okay. And the Kel-Tec, that's a semi-automatic handgun?
Correct.
Okay. And what's the Derringer?
I believe that's a single shot handgun.
You said the 22, the Kel-Tec, that was 22 caliber?
Correct.
Did you also have occasion to look in the kitchen of the home?
I did.
Yeah, first one. This is people's proposed 50. So that's a photograph. Do you recognize that photograph?
I do.
And how do you recognize it?
That's the kitchen at 112 East Street.
And does that photograph fairly accurately depict what you observed that day?
It does.
May I approach, Judge?
Yes.
I'm also going to
Are
give
you
you,
moving on 50 or are you just going to do all of them?
I'll do all at once, Judge. Thank you. I'm going to give you 51 and 53 as well.
Okay.
Take a look at those, please. 51 is on top. Those are also photographs?
Correct.
And those photographs also fairly and accurately depict what you observed that day?
Correct.
People moved to admit 50, 51, and 53.
Any objection? No objection, Your Honor. No objection. The evidence.
Okay. Now, this is 50. This is a photograph of the kitchen.
Correct.
Okay. And so what are we looking at here?
Just looks like the kitchen with the oven. There's an island right across from the sink, and some cabinets underneath the island.
How would you describe the general state of the home?
It was messy.
Okay. What's this bottle we're looking at right next to the kitchen stove? That's on 50.
Appears to be alcohol, bottled alcohol or liquor.
Was that the only one found?
No, there was multiple bottles of liquor and alcohol throughout the kitchen.
Okay. So we're looking at a kitchen island to the left of the screen here. Did you look in that kitchen island?
I did.
Okay. This is exhibit 51. Is this inside the kitchen island?
It is.
And what's this black case that we're looking at?
It's a Kel-Tec handgun box.
Okay. And did you have occasion to open that up?
I did.
In the Kel-Tec, that's the firearm that you found in the locked gun container, correct?
Correct.
Okay. Now here's 53. Is that a photograph of what that black Kel-Tec gun case looked like when open?
Yes.
Okay. And then what's inside here?
That was appeared to be a trigger lock, cable lock of some kind.
A cable lock?
Yeah.
And that's still in its packaging?
Correct.
Now, throughout the search of the home, did you find any cable locks that were broken or tampered with?
No.
Did you find any cable locks that were not contained in their original packaging?
No.
We have one moment, Your Honor. I have nothing further to this witness, Judge.
Thank you. Any questions on behalf of James Crumbley?
Yes, Your Honor, one moment. Good afternoon, Ted.
Afternoon.
So first, we're going to start, when you first went into the home, one of the first exhibits that the prosecution showed you was the empty gun box. Do you recall that?
Yes,
And you spoke with James Crumbley when you entered the Crumbley house, is that correct?
I spoke with him briefly prior to entering the house.
And he told you where his firearms were located.
Correct,
And he directed you where to go.
correct,
And they were all in his bedroom.
correct.
Now, the Keltec that you said there was a Keltec box found in the kitchen. We just saw that. It's empty, right?
Correct,
And you located a Keltec firearm, 22 caliber firearm in the safe, right?
yes,
And it was unloaded, correct?
it was unloaded.
With the Keltec was also a Derringer handgun,
Correct,
and that was also unloaded
correct,
in the safe.
correct.
And then there was another empty gun box that you found on the bed.
Correct.
Now, is it your understanding that James Crumbley had placed that on the bed after he'd located it?
I can't answer that. I don't know.
But the handgun, the empty handgun box and the ammunition were both placed on the bed. They weren't strewn on the bed. Is that fair?
They were seated on the bed. I don't know how they got there or no, they were seated on the bed.
Just gonna look for the photograph. Oh, you have it. I believe it is 40, exhibit 43.
Uh-huh.
Yes. So looking at exhibit 43, they're kind of next to each other on the bed, right?
Correct.
The bed isn't made, but the boxes are seated next to each other. Is that fair?
That's fair.
And there was a question in exhibit 48, I believe, about the cable lock in that box, correct?
Correct.
And the prosecutor asked you if you'd located any other cable locks, right?
Correct.
You didn't.
I did not.
That you have no information to indicate that there was not a second cable lock that was used to secure the Sig Sauer handgun that belonged in that empty hand box. Is that fair?
Yeah, I personally did not recover any other locks that day or cable locks that day.
You didn't find any other locks and wrappings that weren't being used. Is that fair?
Fair.
You didn't find any that had been cut off on the premises.
I did not, no.
And to your knowledge, a cable lock could have been taken with whoever took that handgun out of the box. Is that fair?
I don't think I can answer that question.
You have no knowledge.
I have no knowledge, no.
And also, just to make very clear, all of the firearms, the Keltec, the Derringer, and the Sig Sauer handgun. Obviously, the Sig Sauer handgun was not in the home at the time. The other firearms were all located in James and Jennifer Crumbley's bedroom.
Yeah,
Correct.
the two 22 handguns were located in their bedroom, correct?
Okay. And the empty Sig Sauer box was also in their bedroom.
Correct.
And you have no reason to believe that that Sig Sauer had been stored anywhere other than in the bedroom. Is that fair?
There's actually speculation, Judge. You haven't testified. You can't possibly testify to anything.
Suspect.
One moment, Your Honor. No further questions. Thank you.
Any questions on the Justice Crumbley?
Thank you. When you came into the house, and saw the Sig Sauer case and the ammunition box on the bed, you have no idea when the box was placed there or when the ammunition box was placed there. Is that correct?
Correct.
And when you came into the house, and found those items there, did you ask James and Jennifer when those items were placed there?
I did not.
Did you listen to, or are you familiar with James's 911 call when he reported the missing gun?
No, I never listened to that.
I have nothing further.
Thank you. Any redirect?
Just very briefly. Sir, the Caltech and the Derringer were both unloaded, is that correct?
Correct.
Did you find ammunition for those weapons?
I don't, no, I did not.
Okay, were there
Sorry,
bullets?
that you don't know or you know?
No, I did not. I personally did not know.
I guess not specific to those firearms. Were there bullets found in that dresser as well?
I don't recall if there was.
Okay, that's fair. Now, how far from the school is 112 East?
I'd say around a half mile.
Okay, and it's just a straight shot down that road, isn't it?
Correct.
I have nothing further.
You need to step down.
Thank you.
Play next witness.
Sergeant Pesky. Judge, we have, going to take some of these out as well. Would you like me to approach and?
Yes, please. Sir, please raise your right hand. You solemnly swear in the testimony you're going to give will be the truth under the penalty of perjury.
I do.
Please have a seat. If you please state and spell what the first and last name for the record.
Matthew Peschke, MATTHEWPESCHKE.
May I proceed, Judge? Thank you. Sir, what's your occupation?
I am a sergeant with the Oakland County Sheriff's Office.
If you're comfortable, you can remove your mask.
Thank you.
And you said you're a sergeant with the sheriff's office?
Yes, sir.
How long have you been a police officer?
Approximately 20 years.
Okay. Now, I want to direct your attention to November the 30th, 2021. Were you working that day?
I was.
Did you receive notification about a shooting at the Oxford High School?
I did.
And what did you do?
I went to Oxford High School.
Okay, so you responded to the scene?
Yes, sir.
What did you do while you were there?
While I was there, I entered inside. I helped clear the area of any other victims or suspects, did a perimeter search.
Okay. Now, at some point, were you tasked with responding to 112 East in Oxford?
I was.
And was that to secure the scene for a search warrant?
Yes.
Now, did you go alone with other deputies?
I went with other deputies.
Was anybody home when you arrived?
Yes.
Who was that?
Jennifer and James Crumbley.
Okay. Did you see them when you pulled up?
I did, yes.
Tell me about that, please.
When I pulled up, there was another another detective that was on scene. Jennifer was on a porch and James was in the back. They were having him come out.
Okay. Now, at some point was a search warrant obtained to search the premises?
There was.
And did you participate in the search of that premises once the search warrant was obtained?
I did.
And photographs were taken during the search, am I right?
Yes.
Now, is it true that it is a sheriff's office policy not to take a photograph, well, not to disturb the scene until a photograph is taken?
Can't say I've ever read that in a policy.
Well, let me ask you this. When a photograph is taken of, let's say, a room, is that photograph taken to capture the way the room actually looked, or is it captured to show what the room looked like after it was gone through by the officers?
What it looked like before.
Okay. What was the general condition of the home?
It was an older home. He walked in the living room. It seemed fine. Then he went through the kitchen. The bedrooms were a little messy, particularly the Ethan's rooms were pretty messy.
At some point, were you made aware which rooms were Ethan Crumbley's?
I was.
Okay. May I approach Lynn?
Yes.
I'm going to approach with a few at once. Sir, I'm going to hand you a stack of photographs. I'll identify them as I hand them to you. We have proposed exhibits 59, 60, 61, 64, 65, 66, and 67. Sir, just take a second. Look through these. 59 is on top. Tell me if those photographs fairly and accurately depict what you observed from 112 East on November the 30th, 2021.
Yes.
People move to admit those exhibits, Judge.
Any objection on the Jeff Crumbley? Dr. James Crumbley?
No objection, Your Honor.
All will be admitted.
Thank you. All right, sir, I'm going to start with 59. I'm going to have it up here on the screen as well. If it's easier, you can refer to the exhibit in front of you. Okay, this is exhibit 59. What are we looking at here?
That's the northwest bedroom.
Was it identified to you whose bedroom this was?
It was identified as Ethan's.
Okay. In fact, were you made aware that there were 2 bedrooms attributed to Ethan Crumbley?
Yes.
Okay, so this is one of them?
Yes.
Okay. Now, was this photograph taken before anybody from the sheriff's office went through it, or is this the way it looked?
This was before.
Okay, so this is the way it looked. All right. And what do we see on the wall here?
Those are silhouettes.
Okay, this is 60 here. Is it the same silhouettes?
Yes.
When we say silhouettes, are we talking about
Gun range
gun range
silhouettes.
targets? Okay. So here's 61. What do we see here?
That is a empty bottle of whiskey.
Okay. Was that the same brand whiskey found throughout the house?
There was a bottle of it on the kitchen counter.
Empty or full?
It was,
Sorry.
Empty or full, I said.
I believe it was almost empty.
Okay. And this is again in Ethan Crumbley's room?
Yes.
All right, so that's 61. We have 64, and this is still in Ethan Crumbley's bedroom, correct?
Yeah, this is the nightstand.
Okay, this is the nightstand next to the bed.
Yes.
And so what's depicted in this photograph?
There was miscellaneous shell casings found within the dish.
What's a shell casing?
It's a fired shell casing when a bullet's fired from a gun. If it's a semi-automatic, it ejects a shell casing.
Okay. Those aren't pretend, those are real shell casings, right?
They appear to be real, yes.
Okay. Now, this is 65. What are we looking at here?
That was a coin that was found in like underneath that dish on that plate. It was it had a Nazi symbol on it.
Okay, and that was on his nightstand in his room?
Yes.
Ethan Crumbley's? Okay, that's 65. And this is 66. What's this?
That's just the other side of it.
Okay. Did you put that in that plastic bag or was it like that?
That's how it was.
Now, this is 67. Is this the same bedroom?
It is, yes.
Okay. And did you find anything of note on that tall dresser to the left?
Yeah, there was like animal, like mouse feces and things on it like that.
On that dresser?
Yeah. Yes.
Now, did you also search the other bedroom that was identified as belonging to Ethan Crumbley?
Yes.
My first one.
Yes.
So I'm going to hand you 3 photographs. They are proposed exhibits 69, 71, and 73. Again, if you don't mind, just take a second, go through those, and let me know if they fairly accurately depict what you observed on November 30th, 2021.
They do.
People move to admit those exhibits, Judge.
Any objection on behalf of Jeff Crumbley?
No objection.
No objection, Your Honor. Will be admitted.
Okay, thank you. Okay, 69, tell us what's in there.
This was the other bedroom, the northeast bedroom,
Again, does that photograph depict what the room looked like prior to searching or after searching it?
prior.
Did you find a notebook in that on that bed?
The notebook was located by Detective Steele.
Okay. It was found in that room though?
Yes.
Okay, it was open?
Yes, I believe it was a green notebook.
Green notebook? Okay. And this photograph here in exhibit 71, what does it depict?
It depicts the open notebook.
Okay, so these appear to be drawings.
Yes.
And what are the drawings of?
I can see that one is of a rifle style gun. It looks like there's another handgun on there with an extended magazine possibly. That's really all I can make out.
Okay. Now, were there any weapons found in that room?
There was some folding knives.
Okay. The next exhibit you have here,
Yes.
and this is exhibit 73.
There was a shelf on the wall.
There was a shelf on the wall of this bedroom.
Yes.
Okay, so what are we looking at here in this photograph?
It's a couple folding knives.
And those are real knives, correct?
They appear to be real, yes.
Okay. The shelf wasn't closed off; it was open like this.
Yes.
Now, did you search other parts of the home?
I walked through the rest of the home. At this point, I went into the kitchen and started doing a tabulation.
Okay. Does the home have a basement?
It did.
Right. Does it have a shed?
It did have a shed.
How close to the home is the shed?
Oh,
It's on the property, right?
it's on the property, yes.
Okay. This property doesn't have acres or anything, am I right?
No,
Okay. So this is a home in the township of Oxford.
yes.
Okay. So are we talking a matter of feet from the home to the shed?
Yeah.
Could you put an estimation on it?
I wouldn't say any more than 50 feet.
50 feet at the most?
Yeah.
Okay. Did you look in the basement as well?
I did.
And describe the general, I guess, cleanliness of the basement compared to the rest of the home.
Basement had a couple rooms to it. As you walk down the stairs, there's a kitty litter box at the bottom of the stairs. It was full. You walk through, and in the basement, there was appeared to be a couple rooms that were made with like plastic draped down. It was possibly like an old.
Objection, Your Honor. Relevance as to what it could be, speculation.
I'm going to sustain this to speculation.
I can lay a foundation, Judge. Sir, you've been a police officer how long?
Over 20 years.
Okay, in part of those 20 years, have you had the opportunity to participate in search warrant executions?
I have.
Did you have the opportunity to investigate any drug cases in the past?
Yes.
Have you had the opportunity to investigate and find what you discovered to be marijuana grow operations?
Yes.
Okay, and you know what marijuana looks like?
Yes.
You know what it smells like?
Yes.
Okay. Did you find anything in the basement as an officer, to give you note regarding marijuana?
Objection, Your Honor, relevance as to any of whether or not there was a marijuana grow operation or not in the basement, that has no bearing on this.
Judge, I can lay an offer of proof for the court. Again, both defendants are charged with willfully neglecting their responsibilities. The failure to do that in part is, or doing that in part is their failure to exercise ordinary care. This officer will testify that there was an unsecured marijuana grow operation. And I'm not trying to make a bigger term out of it than what it is. It's just labeled a marijuana grow operation. He's going to testify there was some marijuana found there. It was not in a locked room. It was covered only by a tarp.
I'm going to sustain the objection.
Thank you, Your Honor.
And sir, you said you compiled the tabulation from the search warrant?
I did.
Yeah, one moment here. Thank you. Nothing further, Judge.
Any cross on behalf of Jennifer Crumbley?
Thank you, Judge. Detective, you are not an expert in mouse poop, correct?
No.
So if I told you that was chinchilla poop from an old pet, would that surprise you?
No.
Okay, and so the bits and pieces that you found in the room, it looked like feces from a small animal, is that correct?
Yes.
The coin that you found that was wrapped in plastic, it's fair to say it was wrapped in plastic like a collector's item would be, is that correct?
Yes.
And Ethan actually had many, many coins that were wrapped in plastic all about his room, is that correct?
I can't comment on that. I don't remember seeing any other coins.
Okay, so, but that one was wrapped like a collector
It
coin?
was.
Okay, thank you, I have no further questions.
Any questions of the James Crumbley?
No, Your Honor.
Any redraft?
No, Judge, thank you.
You may step down.
Thank you, Judge.
My call you next witness.
You can call the time, boss.
Your Honor, you may approach.
Gonna do a quick break, about 5 minutes break first.
Thank you, Judge.
Sorry, I was choking. So, all right, I have a dumb question. And sorry, guys, I'm a lot quieter this in the afternoon than I was this morning because I'm actually working while I'm listening. So, I don't, what is this preliminary trial for? To see if they're going to trial? Like, I missed that part. What are they actually doing? I said the same thing, Kat. Yeah, I made it as loud as I possibly can. So what is exactly this preliminary hearing for? Anyone? To see if they're going to. That's what I thought. So the judge makes a decision. They could be let out next week. I don't know. What are you guys thinking so far? All right, that's what I thought. I thought maybe there was something else because their preliminary hearing is pretty fast from when they got arrested. That's why I thought maybe there was another issue that I was missing. Because as you guys know, I just picked this up yesterday. So, I mean, I know originally what happened, but I wasn't sure if I missed something. If there was something else that I was missing. What do you guys think so far? I got some in my throat. The probable cause holder, defendant, answer the alleged offenses set forth. Okay. Yeah, I figured that. I just, like I said, I wasn't sure if I missed something. So, as of right now, do you think that the prosecution is showing their case or no? Legally. Not based on opinion, but legally. But as far as legally though, see, Kiki, I disagree. I don't know. I don't think they've proven the case that they should be held for first-degree homicide. I really don't. I mean, granted, it's not over yet, but I don't think that the prosecution has done that much of a case. Like, if I was that judge, I want to see something a little stronger. If you're going to go after these people for first-degree homicide, that's saying that they are responsible. That they're both being charged with first-degree homicide. That's what it said at the beginning. Even if they go to trial, they should be let out to get things in order. Yeah, that would be nice, but no. This is the first time I'm trying to think it through. Nah, I just don't think that the prosecution has proved that case to date. I could have sworn I saw first-degree homicide. Hold on, let me double check. Oh, you're right. They've been charged in involuntary manslaughter. I could have sworn I saw first-degree murder. Maybe it was like first-degree murder of Ethan, maybe? I don't know. I thought it was first-degree. No, it's involuntary manslaughter. So let me take a look at something. Hold on. All right. In Michigan, manslaughter is similar to that of voluntary. Let me go to okay. Involuntary manslaughter occurs when an individual kills another person without intent or unintentionally. The criminal penalties for involuntary manslaughter are as severe as those for voluntary manslaughter. Additionally, the willful killing of an unborn quick child will result in manslaughter charges. When an individual causes such harm to the mother of an unborn child that it results in the death of a fetus, but does not result in the death of the mother, that individual may be charged with manslaughter. Individuals found guilty of manslaughter will face criminal penalties, which include fines up to $7,500 and up to 15 years in prison. Other factors may affect sentencing, including criminal history. Any person convicted of a felony crime will have a criminal record for his or her lifetime. Criminal record often affects employment opportunities, housing, and the ability to secure financing, along with other aspects. So the max they can get is 15 years apiece. And in my opinion, and it's just my opinion, involuntary manslaughter, they're talking like a DWI. If you not intentionally wrestling and you killed somebody, that's involuntary manslaughter, not your son. It's not like they bought the gun. No, that's what I'm saying. To me, they have not met the criteria for involuntary manslaughter. They just haven't. It is involuntary manslaughter. I must have read something wrong real fast. For some reason, I thought it was first-degree homicide. I thought they were all charged the same. Being criminally negligent equals involuntary manslaughter. Yeah, but they're not criminally negligent. I just read the actual law from Michigan. One punch can kill. That's true. I just don't see where Michigan law follows this. I just don't. You had a legal duty to the victim. You failed. They failed as a parent. That's all they failed of. They were bad parents. That's it. That's how they failed. Just like a million other fucking parents out there that suck at being parents. Prosecution is met burden for involuntary manslaughter. In my opinion, they only have to prove. See, I don't know. I disagree. 15 years max. No, and $7,500 fine, not or. It's the gun. Then give him a gun charge.
We're back on the record of People versus James Crumbley and People versus Jennifer Crumbley. Everybody ready to see it?
Yes, Judge.
Yes, sir. Yes, sir. You solemnly swear in testimony you're going to give me the truth under the penalty of perjury.
I do, Your Honor.
I will just state and spell what you first and last name for the court, please.
Lieutenant Timothy Willis, TIMOTHY WILLIS.
May I proceed? Sir, how are you employed?
I'm employed by the Oakland County Sheriff's Office.
And how long have you been a member of the Oakland County Sheriff's Office?
Over 25 years.
Okay, what's your current role there?
I'm the detective lieutenant assigned to the Investigative Forensic Services Division.
Okay. And tell me, sir, what does a detective lieutenant at the Investigative Services Division do?
I oversee our special investigations unit, our fugitive apprehension team, computer crimes, and our warrants division.
Okay. And what are some of the previous assignments you've had?
I've been a lieutenant since 2016. Prior to this assignment, I was a road patrol lieutenant in Rochester Hills. Prior to that, I was a detective, a sergeant for 10 years, and I did 5 years as a detective sergeant in the Special Investigations Unit.
Okay. Now, would it be fair to refer to you as one of the officers in charge of the investigation in the case of People versus James and Jennifer Crumbley?
Yes,
And also the case of People versus Ethan Crumbley?
yes,
Okay. Now, I say one of the officers in charge because this is a very large investigation, is that right?
correct.
So you work as a part of a team?
Yes, sir.
Generally speaking, what does an officer in charge do?
Generally speaking, we direct the investigation.
Okay. Now, have you had the opportunity to review the narrative reports generated in this case?
Yes,
Have you been made aware of the 911 calls made in regards to the November 30, 2021 Oxford school shooting?
yes,
Now, first of all, I want to ask you, as officer in charge, you sat through the hearing today as well as February the 8th, is that right?
correct.
And you were present when we admitted Exhibit 10, which would be text messages between Ethan Crumbley and Jennifer Crumbley, and specific the last text message that said, "Ethan, don't do it." You were here for that?
Yes,
Okay. And do you recall the time on that text message?
122,
Okay, 1:22 in the afternoon. And what time did James Crumbley call 911, if you recall?
1:34 p.m.
Okay. And tell us, sir, if you know approximately what time did the actual shooting begin?
12:51,
Okay. And do you know the time the shooting actually stopped?
12:58.
Now, at 1:22 p.m., had the shooter's name been made public?
No,
At 1:34 p.m., had the shooter's name been made public?
no.
How many 911 calls were made on November the 30th, 2021 regarding the Oxford High School shooting? 100 phone calls. How many of them identified their own son as the possible shooter?
But just one, James Crumbley.
James Crumbley. Now, sir, you were here when Sean Hopkins testified, correct?
Yes,
Okay. And you heard testimony from Mr. Hopkins that James Crumbley asked Ethan Crumbley about his journal,
yes,
and you were here during the cross-examination of Mr. Hopkins,
yes,
and you were here during the cross-examination of Mr. Hopkins when he was asked more questions by defense counsel about that journal.
yes.
Have you had the opportunity to read the journal?
I have.
Well, first, let me back up. Were you made aware that a journal was found with Ethan Crumbley's belongings on November the 30th, 2021?
Yes, I was.
And where was it found?
It was found in the bathroom that the video showed Ethan went in just prior to the incident.
Okay.
He entered with his backpack. He exited without his backpack. The backpack was found in the bathroom with his journal.
Were you able, when you read the journal, were you able to identify it as being written by Ethan Crumbley?
I was.
How so?
Well, his name was all over it in it. The way his handwriting was very similar. In fact, the way that he makes his D's are very unique. It's almost like a number 2. He references the bird head incident. He references his best friend that we know. We've come to know who that is.
So it's not just from the handwriting or from the location, but also from the content as well?
Correct.
Is that fair?
Yes, sir.
Okay. Now, could you describe what the actual journal looks like?
Yeah, it's a hardbound black journal with apartments.com imprinted on the front of it.
Okay. Now, was there writing throughout the entire journal?
The writing starts about 3/4 of the way into the journal, and then it fills up the rest of the book.
Now, from reviewing it, are you able to tell if the first written page on there closest to the front, if that was the first entry in the journal or the last entry in the journal?
The last entry of the
And
journal.
how are you able to make that distinction?
Based on the date that was written in it of 11/29/21.
Okay. And if you were to, let's say, make a photocopy of just the written pages of the journal, how many pages would it be?
21.
Out of those 21 pages, how many discuss the Oxford High School shooting or his plan to shoot up Oxford High School?
Every single page.
Every single page.
Every single.
Now, is this journal all in written format or drawings contained as well?
No, both written and drawings.
Okay. Now, because this is a preliminary examination, I'm just going to ask you about a few pages here. Now, we talked about the first written page and how it said, well, first of all, it being 21 pages long, if I showed you a photocopy of it, would that refresh your recollection when we talk about it?
Yes, that'd be helpful. Thank you.
May I approach witness? Yes, sir, just for identification purposes, what have I handed you?
This is a photocopy of the journal that we found, that Ethan's journal found in the bathroom.
Okay. So what we have here labeled as page 1, that's not an actual written page, correct? What is that of?
No, that was the inside cover of the book. It's, you know, just states at the top, property of Ethan Crumbley.
Okay, so just so we're all clear, page number 2 is the actual first page written in the journal, closest to the front of the journal. Is that right?
That is correct.
Okay, and you testify this appears to be the actual last entry of the journal?
It appears to be, yes.
And is this where it has a date on there?
It does.
Okay, what else is on there?
It has it at the very bottom, in big bold letters, the words "forgive me."
Okay. If you were to flip the page, what did you see there of note?
Toward the bottom half of the page, it says, "First off, I got my gun. It's a SP 2022 6-hour 9mm. Second, the shooting is tomorrow, comma, I have access to the gun and ammo."
Okay. Now, you said there's drawings in there as well?
Yes.
Okay. Now, again, I'm not going to go through every single page here. I'm going to direct you to what's been labeled as page 15. As far as drawings are concerned, what do you see here?
It appears to be drawings of two separate bullets. One's labeled a 22, the other one's labeled a 9mm. The 22 next to it has kill range 25 M max, and the 9mm has kill range 100 M.
Okay. If you were to flip the page to page 16, is there a drawing on that page as well?
There is the bottom half of the page, a large drawing of what appears to be a cup with liquid in it, a severed bird head, and what I could only describe as a demon standing drawn next to it.
Okay, now is this a little drawing or is it a bigger drawing?
It takes up the bottom quarter of the page. It's a large drawing.
Now, what about on page 18? What do you see on that page with regards to drawings?
From the drawing, it appears it's the drawing of a head with where the eye is an X. The head appears to have a ponytail, and then a gun extended, a semi-automatic handgun extended out with a round being fired into the back of the person's head.
Okay. Is there any context to that drawing? Any written context?
Just above it, it says the first victim has to be pretty girl with a future so she can suffer like me.
And you said that drawing of the gun, it depicted a semi-automatic handgun?
Correct.
And earlier you referenced the passage where he says, I have access to the gun and ammo. It's an SP 2022 6-hour.
Yes, sir.
What is SP 2000? I'm sorry, SP 2022. What is that?
That is the model number of the weapon used in the shooting.
And is that a semi-automatic handgun?
It is.
Okay. Now, if you flip through the journal, are some passages written with larger letters, bolded letters?
Yes.
Okay. If you were to flip the page to page 19, what do you see there?
In the middle of the page, in all caps, I will kill everyone I fucking see.
Is there any context made to that statement?
Just above it, it says, I will cause the biggest school shooting in Michigan's history. And then he goes on to say, I will kill everyone I fucking see. I have fully mentally lost it after years of fighting with my dark side. My parents won't listen to me about help or a therapist.
Okay, I want to refer you back to page 6 now.
6.
We talked about some bolded letters. And this isn't just a few pages, right? It's throughout the journal. Is that fair to say, the bolded letters?
Yes, sir.
Okay. On page 6, does anything jump out at you?
The word help in bold letters colored in.
Is there any context to that word?
Yeah. In that, right next to help, it says, I have 0 help for my mental problems, and it's causing me to shoot up the fucking school.
Maybe one moment here. I have nothing further.
Any questions on behalf of Dr. Crumbley?
Yes, Your Honor. Good afternoon.
Good afternoon.
You just testified about the journal that was found in Ethan's backpack. Is that correct?
Yes, ma'am.
And you testified it was approximately how many pages? 20?
21.
21
21
pages?
written pages.
Okay. And I'm holding up what I believe is a copy of it. Does this look close to what you have?
Yes, ma'am.
Okay, thank you. Now, throughout this journal, you testified that you can see it's Ethan Crumbley's writing in the journal, and you can tell it's his writing based on the way he shapes letters, correct?
Yes.
It's fair to say that the only person who you can identify having written in this journal is Ethan Crumbley.
Yes.
There are no messages written in the journal like to Ethan from mom, you know, anything like that.
No.
There's no messages in there like from James saying,
That's not me, that's them. I think their news feed just went out. Uh-oh. See, Nikki, I don't think so. And I'm going to tell you why. Oh, I'll tell you a break.
Speculation. He can testify what writing is consistent of, as far as possession, the court knows that's a legal concept. So you want to testify to what you're doing.
I think she needs to rephrase too also.
okay, the journal that was found is believed to be Ethan Crumbley's journal, correct?
Yes, ma'am.
And on the front, it actually says property of Ethan Crumbley, correct?
Written, yes.
Okay, and in the journal, in addition to writing about school shootings, and other issues, there's also a continuous message of, I love you, Mom, I love you, Dad, I'm sorry, please forgive me. Is that correct?
A continuous message?
Well, let's start with page 775. We see there that he writes, yeah.
Oh, okay, okay. I'm
Okay,
sorry.
so in that first part, we see there's a message there that says, I'm sorry for this, Mom and Dad. I'm not trying to hurt you by doing this. I have to do this. Do you see that?
Yes.
And that's in Ethan's handwriting, correct?
Yes, it appears to
Okay.
be.
And then below that, there's a paragraph that's indented just a bit. And again, it says, I love you, Mom. I love you, Dad. I'm sorry for never saying it back. And then I love you to pets. Do you see that?
Yes, I do.
Okay. And then going a couple pages into the journal, I guess let's go towards the back. The second to last page. there's a little, it would be page 21 on what the prosecutor gave me, page 794 of what I have. On the bottom left-hand corner, you can see where he writes, "I hope my parents can forgive me for what I do." Do you
Yes.
see that?
Yes, I do.
And in this journal, it's fair to say that there is nothing that indicates Jennifer and James know what Ethan is going to do in terms of the school shooting.
Repeat it, please. I'm sorry, ma'am.
There is no evidence in this journal that shows Ethan told his mom and dad what he planned to do in terms of that school shooting.
No, ma'am.
And if anything, his messages about his parents are more so ones of, "I love you and please forgive me."
Yes,
From what
in the
you've
journal.
seen.
Yes.
From what you've seen.
Yes.
On the last page of the journal, so it would be page 22 on what you have, and it's page 795 on what I have. I want to draw your attention to the left side of the page. There's writing written up the side. Do you see where it reads, "I will have to find where my dad hid my 9mm before I can shoot the school"?
Yes.
Now, closer to the front of the journal, Ethan mentions that at another point in time, he has access to the gun and the ammo, correct?
Yes, I believe that's what, page 3?
On mine, it's page 776. On yours, it's page, yes, 3.
Okay.
Okay, so on that page, he writes, "The shooting is tomorrow. I have access to the gun and the ammo," correct?
Yes.
And it does not say in this how he has access to the gun or how he gained access to the gun, correct?
It does not say that.
It does not say how he has access to the ammo or how he gained access to the ammo.
You're correct.
And so from reading his journal, even knowing he had access to the gun, you cannot say that Jennifer or James Crumbley gave Ethan access to the gun.
By reading this journal, you're correct.
There is no way to draw conclusions about what Ethan did to gain that access, correct?
Objection to the form of the question, Judge. It goes to the court report.
I believe the witness was already answering. I don't think it was confusing. I'm not sure.
I'm going to overrule the objection. That being the question is whether it was confusing to the witness and computer respond. Go ahead.
Thank you. Now, this journal also, just so we can be clear, was found in Ethan's backpack, correct?
Yes.
And when I say backpack, I'm talking about the bag he used at school that he had the last day he attended Oxford High School, the day of the school shooting, correct?
Yes.
And this journal was found in the backpack where the gun was also located.
No.
Well, the gun was located there at some point in time prior to the shooting. Is that correct?
I don't know what you mean, ma'am. The gun was.
I'm sorry. You know what? I'm asking a really bad question. Let me back up. The backpack had certain items that remained in it. The backpack was found in a bathroom by law enforcement. Is that correct?
Yes.
And in the backpack that belonged to Ethan, that is where his journal was found. Is that correct?
Yes.
When you found the journal in the backpack, you have no other knowledge of where that journal had been other than in Ethan's backpack, correct?
I have no. I'm sorry, miss. Can you repeat that, please?
You don't. So, for example, you can't say this journal was on the kitchen counter at home where someone would have seen it. This journal would have been here or there. All you know is that that journal, the last, when you saw it, was in Ethan's backpack, correct?
Yes.
Your Honor, may I have just a moment? You were able to tell chronologically how the journal was written, correct?
You mean when it was written?
Yeah, like what, were you able to tell that Ethan wrote some passages and then wrote passages later in time?
It appears that way by the way the journal's written, yes.
Do you agree with me that the statement about I need to find where my dad hid the gun, that statement comes before Ethan saying he now has access to the gun?
Judge, I have to object to the form of the question. I don't think there's
What
any.
is the same? Go ahead, Judge, please.
The last page of the journal talking about I will have to find where my dad hid my 9mm before I can shoot the school. This writing was written prior to the writings at the top of the pile on the journal pages.
Is that a question, ma'am?
Yeah.
Okay.
Does
So-
that sound correct to you?
Yes, I mean, I can't say for sure this is a margin writing. It doesn't seem to be, but I don't know. I don't
You
know.
have no reason to disagree, though. Is that correct?
It's speculation. You can't answer. You can't.
Same.
I have nothing further.
Any questions on behalf of James Crumbley? Not your honor. Any redirect?
Just very briefly. Sir, you said on the whole 21 pages here, every single page references the school shooting?
It does.
Okay. And if you were to just flip through quickly, we talked about there's some pages with these bolded letters. This is 6 with the word help in there.
Yes.
Okay. And that's where he says, I have 0 help for my mental problems, and it's causing me to shoot this fucking school.
We're going beyond the scope of the cross at this point.
You were asked about the very last page, on page 22, and I just want to make sure I heard your testimony correctly.
Okay.
The passage in there was, he had my 9mm. Is that correct?
That is correct. I will have to find where my dad hid my 9mm before I can shoot up the school.
And if
Shoot
you were
the
to look
school,
at,
sorry.
if you were to look at page 3, that's closer to the front of the book, right?
Yes.
And that's where he writes, first off, I got my gun. It's a SP-2022 6-hour 9mm.
Correct.
Okay. And then he writes, second, the shooting is tomorrow. Is that right?
Yes, sir.
Okay. And the page just before this identifies the date as November 29th of 2021.
Yes, sir.
And that is actually the gun that he used for the school shooting on November 30th, 2021.
The 6-hour SP 2022. Yes, 9mm.
I've nothing further.
Your Honor, may I briefly
Dennis, go, please.
Okay. The prosecution brought up the word my in terms of my gun. When you handle cases where a teenager is driving a car, there are times when it is owned by their parent, correct?
Yes.
Even
Objection is irrelevance.
even if they call it my
Objection,
car,
objection is irrelevant.
the prosecution is trying to make my mean that it's absolute possession when it's very obvious that my gun is technically his parents' gun. It does not mean it's his gun that he has free access to. The prosecution has been tainting the whole hearing.
All he would do is testify as to what was actually in the journal itself and the language that is in the journal.
Right.
So and that's what he testified to.
And I'm just asking him that in circumstances when a writing says my something and a teenager has written it, sometimes they're referring to
Well,
property.
you are asking him to speculate at that point because you're asking him to get into the head of some other teenager
Okay, I have nothing further, thank you.
Nothing further.
You may step down. And call your next witness.
Trying to keep a rest.
Any defense witnesses?
No, Your Honor.
I'm gonna take 5 minutes and I'll come back for, the argument motion.
Thank you, Judge.
All right. So we have 45% saying that I'm super nosy. I'm sorry, but I completely disagree. That's why I said be 100% honest. I still have my journals from when I was young. And my mom actually brought them to me last time she was here. That was my safe haven. That was my place to put out whatever I wanted to talk about in my own head. If anybody would have read it, I would have been mortified. You don't look through your kid's personal journal. Sorry, but you just don't. It's just wrong on so many levels. Like, kids need to feel a safe place. They need to feel like they can let out their feelings that nobody else is going to find out. Nobody else can see them. You know, these are their thoughts. So I would never invade my kid's space, ever. I would never invade their journal. I know Sage sometimes keeps one. Dayton's been keeping one. Unless I got some kind of, you know, feeling that something was like way off, then I would say something. Or maybe look at it. But if my kids seem okay, I'm sorry, that's their safe haven. And now they're expecting exactly, Rad. I mean, my parents did. My parents told me that all the journals they bought me, that was my safe haven. That was my place to, you know, say whatever I wanted. And shit, if people read my journals, they would think that I was going to kill my parents. I mean, there were times this entry like sticks out to me. I was like, I'm 13 years old. How dare they say that I cannot fucking, that I can't fucking go in a car with a boy. I was 13. I was like, I fucking hate them. I hope they die. I was like, they treat me like I'm a little baby. Yeah, I was 13. I was reading this. I was cracking up. So I would think that if my parents read that, they would have locked me up. Some of the shit I wrote in there. I hope this guy gets hit by a car. Like, it's just the way it is. So if they're trying to say that the parents are responsible because they didn't look at their 15-year-old boy, not even a girl, their 15-year-old son journal, that's bullshit. I can't agree with that. I'm sorry. No. I stopped looking in my kids' book bags except when I clean them, but I literally stopped looking in their book bags. Oh, I don't know. 6th grade? 7th grade when they got out of elementary school? I couldn't even tell you the last time I looked in Phoenix's bag. End of the year is when I look in their bag. If that makes me a bad parent, so be it. But I'm not too worried about it. I would never invade my kid's space. I bought Dayton a book to do some writing because Dayton's becoming a pretty good writer, actually. And I bought him a book and a pen. He's like, Mom, I do everything on the computer. And I said, okay, but here's a pen. If you get an idea, you can write something down. You know, I'm not going to go snooping in it. I'm not going to go looking in it. You just said that you wouldn't do that because your kids seem okay. Yeah, but we don't know the kid. We don't know Ethan. Maybe Ethan was a different person in front of his parents. you know, maybe his parents blew him off. He was like, yeah, whatever. I've done that. You know, Sage would be like, Ma, I need a doctor. I have anxiety. No, you don't, Sage. You don't have anxiety. I was like, you're just lonely. And then she gets a boyfriend and it's perfectly fine. But if she would have blown up a school, there'd be witnesses say, well, you have anxiety. No, I know my daughter. She's just broke up with somebody. She's depressed. You know, we don't know the situation there. We just don't. It would only be the negligence of a school mandated. They took Ethan and they refused. And that's very true. Okay, kids agree when your kid's being weird and having behavior issues, all bets off. Well, okay, but maybe they just weren't around enough. And like I said, we don't know anything about him. What if the dad was Mr. Macho? What if the dad didn't believe in psychiatrists, which I'm sure is coming next? If they go to trial, I wouldn't doubt that that's coming. That their religion doesn't believe in psychiatrists. I wouldn't doubt for 1 second someone pulls that one. Exactly, Mirabella. He told his mom he was seeing demons and the house was haunted. So that leads me to believe he absolutely is not insane. What this has proven here throws out his entire defense. His entire insanity defense. Done. If my kid was telling me he was having ghosts and he was seeing things, yeah, I would automatically bring him somewhere. Now, on the flip side of that, and this I just thought of, what if they bought him the gun but told him not to touch it just for his own protection? Being that with his protection, like if he was seeing things, at least a gun would help out thinking he wouldn't hurt someone. I don't know. I'm just saying. She also was finding pot my baby brother hid inside Devil Music album covers. Hey, I hid inside Devil Music. Tell Sage she's gorgeous and she don't need no boy. I'm just telling you, Sage always gets, oh my God, this overriding anxiety as soon as she breaks up with someone or she's upset. Then as soon as she gets happy, as soon as she gets with someone again, oh, I'm so happy, ma, no more anxiety. But if she did something in the process, people would look at me like, I was like, look, I know my daughter. I know what's wrong with her. And I haven't been wrong yet. My kid said that I take him straight to medical care. What, that he was hallucinating? Yeah, I agree. He could have an evil spirit attached to him. Now, the only reason I don't think that, Valentina, he specifically said in this journal that he asked his parents for help and they weren't giving it to him. A, he's not insane. B, he's 15. Why didn't he go somewhere else and ask? When he was on... No, I didn't, Valentina. I know my kids have a journal. I couldn't tell you what was in it. Well, Lindsay, because of... I don't know. I think the parents are just as responsible as the kid. And I'm sorry, as just as responsible as the school. And I still say his friends are partly responsible. I know Valentina, but some of her friends, some of her besties have overriding anxiety. So Sage has overriding anxiety. But I know my kids. He was neglected emotionally. I absolutely agree with that. They were not the best parents. I'm not denying that. But I don't think they belong in prison. It's hard for teenagers to reach out for help. And if he was rejected by... Yeah, I thought of that too after I said it. I did. I thought of that too. I'm like, well... who has more responsibility over your kids? Oh, absolutely me. But Lindsay, I'm home with my kids all the time. If I only see my son 3 hours a day and school gets him 8 hours a day, kind of rough. That's where parents ask for teacher help, basically. I mean, I don't think they're any different than any other parent out there that they don't think their kid would do something like that, or they're going through a phase, or they are something. Ethan's friends knew about the shooting. Yeah. One of his friends says, "Hey, go blow up the school." Just kidding, just kidding. His friends knew. His friends are just as responsible as his parents. Actually, they kind of pushed it on him. I totally agree, Valentina. My grandson told his doctors before that he saw dead people and they believed him. He was totally lying to them. Exactly. There's $100 million. There is a $100 million lawsuit against school, as there should be. His parents don't have the degrees that the school psychologist has. School psychologist in the school should have told him, no, don't come back. I think everybody's just as responsible. Even if the parents get off, they're going to get sued up the ass. They're never going to have money. They might be better off in jail. Amanda, I don't know. When I was in high school, I called a teacher, Mr. Trudnak. I told him he was a 2-time flying F word and that I hated him. I was suspended. Not only did I get suspended for a week, it was mandatory, and I had in-school suspension for the entire year. Which was kind of worse than what Ethan did before he got out. Before he went back to class. I will, as soon as this comes back. Well, I already gave the definition of involuntary manslaughter. How many people let their parents... Absolutely, Pixie Dust. Definitely not. And I would never do that to my children. My mom never read my journal. She read it later. But I would never... That was my safe place. All right.
We are back on the record of People versus Crumbley. Both parties have rested with their witnesses for purposes of preliminary examination. Is the prosecutor ready for the motion? Yes, ma'am.
Judge, we spent 2 days and over 12 hours listening to witnesses testify, lawyers arguing, and reviewing evidence. Before I begin, though, this afternoon, I want to first talk about 4 people that we haven't mentioned by name. They are Hannah St. Juliana. She was 14 when she was killed from a gunshot to her back, abdomen, forearm, and thighs. Tate Meir, he was 16 when he was killed from a gunshot wound to his head. Justin Schilling, he was 17 when he was killed from a gunshot wound to his head. And Madison Baldwin, who was 17 when she was killed from a gunshot wound to her head. This exam is as much about them as it is the defendant's guilt. Your Honor, you are an experienced jurist, and I know that you know the burden that I have today. But for the record, my burden is to show that there's probable cause to believe a felony was committed and that James and Jennifer Crumbley committed it. Each defendant has been charged with 4 counts of involuntary manslaughter, and this court knows this is defined in Michigan by an unintentional killing without malice. There are 2 ways we will show and have shown that the defendants are guilty of involuntary manslaughter according to Michigan law. One is a gross negligence in the performance of a lawful act. The second is gross negligence in the failure to perform a legal duty. Your Honor, both Jennifer and James Crumbley were grossly negligent when they failed to perform their legal duty as a parent. As parents, we have a legal duty to exercise reasonable care to prevent others and the community and third parties from our child hurting someone else. As parents, we all know this, but it's also well settled in Michigan law. They are also grossly negligent in the storing and securing and buying of a firearm. Gross negligence is defined as a willful neglect and disregard to the results and a failure to use ordinary care to prevent an apparent result. And for both of those theories, Your Honor, we are required to look at what each defendant knew. So let's talk about that. Both Jennifer and James Crumbley knew, the evidence showed, that their son was experiencing disturbing mental health issues in the months leading up to the shooting. He texted his mother, Jennifer, in the March before. March 9th, 2021, 7:50 p.m. Ethan says, "Can you get home now?" No response. 7:50 seconds later, "There is someone in the house, I think." No response. Seconds later, "Someone walked into the bathroom and flushed the toilet and left the light on." No response. "And I thought it was you, but when I came out, no one was home." No response. "There is no one in the house though." No response. That was at 7:51. At 8 o'clock, "Dude, my door just slammed." No response. "Maybe it's just my paranoia." At 8:01. Seconds later, "But when are you going to get home?" Your Honor, based on the testimony of Detective Wogrowski, we know that there was no response. There was no call. And the next communication we see is the following day. And Jennifer Crumbley texts her son, where's your dad?" We also know that on March 16th, that same month, 3:18 p.m., "Okay, the house is now haunted." No response. That's at 6:03. Seconds later, "Some weird shit just happens and now I'm scared." No response. Seconds later, "I got some videos." No response. 6:03.
Hold up. In all fairness, maybe she was working and she didn't see her phone. I don't see my kids text all the time. Sometimes they go hours and I don't see it because I'm working or busy and not staring at my phone. So I'm sorry, but I disagree with this.
3, and a picture of a demon. No response. "It is throwing bowls." No response. "I'm not joking, it fucked up the kitchen." No response. "I'm just going to be outside for a while." 6:29. "Can you at least text back?" No response. We know from the testimony where James and Jennifer were. They were at the stable taking pictures of themselves on horses. We also know that they had evidence that they were told, based on the comments in the journal that was just testified to by Detective Tim Willis. And perhaps the most chilling, from the words of their son, a day before he murdered 4 people. "I have zero help in my mental problems, and it's causing me to shoot the school. My parents won't listen to me." According to his journal, he told his dad he needed help according to the text message that to his friend, he told his dad he needed help, and his dad told him to suck it up. We know from texts between both defendants that he had a rough night sometime in March, so much so that he didn't know where or how he woke up or how he got there. Both defendants knew he wanted a gun. Both defendants knew he was obsessed with violent content. There was a picture of a target, too, we saw today on his bedroom wall. He's 15 years old. He's got nothing on his walls except 2 targets with bullet holes in them. We know that the defendants James Crumbley purchased that gun for him, and that mom then posted somewhat bragging about it in her Instagram post. I'm having trouble with the visual here now, so I'll just read it. November 27th, 2021, Mom and Sunday testing out his new Xmas present. My first time shooting a 9mm, I hit the bullseye. There's a picture of the target. Apparently, Mom's boasting about her skill in firearms. A picture of the gun, and a picture of a Christmas tree. We know that Mom took him shooting based on that text and based on the evidence that came in today in the testimony. We know that on the day before the shooting, Jennifer Crumbley received a voicemail from Pam Fine, alerting her that her son was scrolling through the phone and searching ammunition. And chillingly, we know that Mom, when reporting that to her son that day via text, says to her son, "Did you show them a picture of your gun?" And then her infamous text, "LOL, you have to learn not to get caught." Your Honor, both Jennifer and James Crumbley knew that their son had access to that gun. There was not one shred of evidence that that gun was locked. The only locked mechanism in the house you heard today was to lock up 2 of the guns they had, and the combination was 000. There was nothing in the house that indicated there was a cable lock. The only cable lock that was found wasn't in its package. They knew that their son was trained. We saw a video of that today. He knew exactly what he was doing. This is not somebody that was new to a firearm. They knew that he was isolated, that he was spending hours by himself at home. And how do we know that, Your Honor? We know that because Kira testified our first day what kind of hours they spent at the stable. Now, I suppose you could say they're great horse owners, but what you can't say is that they were with their son 3 to 4 times a week, 2 to 3 hours a time after work, and lots of testimony to say he didn't want to have anything to do with the stable. He was not there with his parents. Jennifer texted James on the day of the 30th, "I am very concerned," after being shown the math worksheet. James replies, "WTF." Both defendants knew that Ethan had no friends. He had one friend. And Jennifer Crumbley repeatedly told people, she told people at work, she told Kira, he had no friends except one. And that friend was taken away abruptly in October and sent to some treatment.
All right, hold on. I just thought of something. No, the prosecution is a Democrat that is making this about gun laws. But I just thought of something. What if they bought him the gun, and this is just a thought. What if they bought him a gun thinking that that'll help his head? Or, like, that would make him feel better if, you know, they got him a gun that would make him happy. Maybe they thought that that would make him happy. Maybe they thought that, you know, that would make it better. Is that possible? I don't know. That's what I just thought of. We know they're not we know they're not the greatest parents in the world. So maybe they thought that would change his mood. That would make him happier. I don't know. It's just a thought. Very possible, though.
We know that Jennifer Crumbley said her son was weird and he wasn't normal. And then, Your Honor, we know that on the morning of the 30th, just hours before the shooting, they received the math worksheet. And the math worksheet says, first of all, it's a picture drawn of a gun that's identical to the picture of the actual gun they had purchased for him. There are words like, the thoughts won't stop, help me, blood everywhere. We learned from Sean Hopkins that James Crumbley said he knew about that journal. He referenced it to his son. Both James and Jennifer Crumbley, the evidence shows, followed their son on Instagram. And the testimony shows what kinds of things he was posting on Instagram, which were disturbing. Also a picture of the gun, calling it his new baby. Those are all the things we know. The testimony shows that they knew. But let's talk about the things that, through the use of ordinary care, they would have uncovered using ordinary care. If they had looked at the journal, they would have seen that every single page out of 21 pages references a school shooting. They would have read the words, I got my gun, shooting is tomorrow, I have access to the gun and ammo. They would have read, the first victim has to be a pretty girl with a future so she can suffer like me. I'll kill everyone I see. My parents won't listen to me. I have zero help with my mental problems. We heard through Detective Wagrowski and the text messages that their son texted to his friend over and over and over again. I told my parents, I need help. I'm having a mental breakdown. My dad told me to suck it up. My mom thinks I'm on drugs. She laughed at me. I also have to prove that this was foreseeable. We need only look at their own actions that day. Jennifer Crumbley, before the news was public, who this shooter was, at 1:22 p.m., texted her son, Ethan, don't do it. James Crumbley, upon learning there was a school shooting and couldn't get a hold of his son, went to his house and looked for the gun. He didn't go to the mire like all the other parents to try to find his son. He went home to look for the gun. And then at 1:34, he called 911 and we listened to his call. Your Honor, you can't argue. You can't even possibly consider that this was not foreseeable. When the moment you hear about a school shooter, you go look for the weapon you just bought him and then call 911 and say, I think my son's the school shooter. And Jennifer Crumbley's text to her son, Ethan, don't do it, before it's ever made public. I also have to prove that the defendants could have done something to prevent this. let's talk about that. They could have taken him home or to get help that day, as Sean Hopkins asked them to do. Did they do that? No. Why not? They said they had to go to work. We heard testimony from Jennifer's employer. She absolutely did not have to come back to work. It's a family-friendly environment. They would have understood she did not have to come back to work. This is not a situation where somebody is going to get fired if they don't come back to work. But by the way, most parents wouldn't care about that. They would just take their son. In fact, she came back to work, talked to Amanda and said, I guess I'm a failure as a parent. And what did Amanda say? You should probably go get him. She states to Amanda, he can't be alone. James Crumbley was a DoorDash driver. I think the court can take judicial notice that being a DoorDash driver is completely your work hours optional. When you start, optional. When you finish, optional. If you take a break, optional. The fact that they looked at Sean Hopkins in front of their son that day and said, we can't do it. Won't work. We have to go to work. It was preventable. They could have gone home to see if the gun was there after they met with the school. They didn't do that. They could have locked the gun and made it completely inaccessible to their son. They did not do that. We have Ethan's own statements saying they didn't do that. And we also have the other big thing, which is that that was the gun he used to murder 4 people. They could have asked him on that day where the gun was. They could have told the school that they had just purchased a gun for him. They could have looked at them in the backpack and asked if it was there and asked to see the journal. They could have taken him to the doctor. They could have looked at his phone. And what happened as a result, Your Honor? Had they exercised reasonable care to control their son, Hannah, Madison, Tate, and Justin would still be here. This was a direct and natural cause and a result of this gross negligence. Your Honor, my burden is to show there's probable cause to believe this crime was committed. I believe we have shown that today. I also believe that on behalf of the people of the state of Michigan, that it is time for Jennifer and James Crumbley to face a juror of their peers in a criminal trial. And I believe at that trial, they will be found guilty beyond a reasonable doubt. Thank you.
Response on behalf of Jennifer.
Thank you. Your Honor, the gravity of the losses that took place on November 30th of last year cannot even be stated in all fairness to the victims in this case. The community is hurting. There was a very tragic loss of life. Many were hurt. Families will never be whole. And there is no question that people in the community want accountability to hold someone responsible for the deaths of these young people and the injuries that took place to many more. The law, unfortunately, doesn't work that way. The person who is accountable for this case, Ethan Crumbley, he will be held accountable. And just because it is such a great tragedy does not mean that the law starts to expand into things it's not. And that is what the prosecution is asking you to do. To prove involuntary manslaughter, the prosecution must prove it in 2 ways. First, that the defendant caused the death of the deceased, and that the defendants acted in a grossly negligent manner. In looking at what a grossly negligent manner is, the defendant has to know of the danger to the other and know there was a situation that required them to take ordinary care to avoid injuring another. And the element that the prosecution in this case can never prove is that Jennifer Crumbley or James Crumbley knew that their son was going to commit a school shooting and shoot people with a gun, shoot anyone with a gun. There is also a way of proving involuntary manslaughter when the defendant had a legal duty to the deceased, to the students who were shot. The defendant knew of the facts that gave rise to that legal duty, and that the defendant willfully neglected or refused to perform that duty. There is absolutely no legal duty in this case that Jennifer Crumbley or James Crumbley owed to any other student at Oxford High School. Just because it sounds good to come up with a bunch of things that could have been done or should have been done or would have changed the trajectory of that day does not mean that a legal duty is somehow born and created. When the prosecution argues gross negligence and talks about what the defendants knew or should have known, it's actually not a question about what they should have known. The jury instruction reads that it's about what the defendants knew, and they had to know that their child was going to commit a school shooting. Out of all the evidence that was presented, there were absolutely no text messages or Facebook messages that showed Jennifer Crumbley was ever given information that her son would commit a school shooting. There was absolutely no evidence that Jennifer Crumbley ever saw the journal that indicated her son was going to commit a school shooting. There was no information that a teenager texting his parents about believing the house was haunted would create any belief that that child was going to go and shoot people in a school shooting. When the Crumbleys had a rough night with their son that was talked about between them the next day, talking about how their son ended up in their bed, there was no way to say that that incident would predict and foreshadow their son would shoot up a school. The prosecution absolutely cannot prove that Jennifer or James Crumbley knew that there would be a school shooting. The prosecution knows this, which is why they have stretched hard to bring in evidence, what looks like evidence, to make these people look like the worst parents in the world. At the end of the day, the law doesn't care about what kind of parents they were. It cares whether they knew their son was going to commit these murders. And Jennifer and James Crumbley did not know that any murder would be committed. Jennifer and James would have been horrified had they believed a murder was possible. And the extensive testimony from Sean Hopkins, who is a trained professional that did a risk assessment on Ethan Crumbley, and he did actually have a legal duty to take certain actions that he didn't even think he needed to take. Sean Hopkins was afraid this child was suicidal, not homicidal, not that he was a threat to anyone other than himself. And so when Jennifer texted Ethan later that day, after hearing there was a situation at the school, and said, "Don't do it," it makes perfect sense that she would have believed she was stopping a potential suicide after Sean Hopkins had discussed suicide and suicidal ideation with the parents earlier that day. To suggest that Jennifer said, "Don't do it," because she knew her son was going to go into a school and take that gun and shoot students, the evidence does not add up to show that. The prosecution is overstating so much of the evidence to suggest that the voicemail Jennifer Crumbley received about Ethan looking up bullets in the school should have made her know he was going to commit these murders is just complete insanity. We all heard the voicemail. The prosecution admitted it as evidence. In that voicemail, Pam Fine says, you know, shooting and going to the gun range is a hobby, and you don't even have to call me back unless you have questions. How would any person take that message and believe their child was going to go commit a school shooting? There's just no logic that would connect one dot to the other. Talking about Ethan being at home for periods of time while his parents are out with horses and playing video games and doing things alone, there is nothing to suggest that a child who spends 3 to 4 hours at home alone would be expected to go and shoot up a school. That is just not something that a person would logically expect to happen. And any parent this day and age, and I speak as a parent of 4 children, knows that children get busy with video games, their own things, their own lives, they're online. Life is different these days. And to suggest that Ethan being alone would lead to the conclusion that he would shoot up a school is absolutely ridiculous, especially after all the alone times our children have spent over these last 2 years through COVID. The arguments that the parents could have taken him home, they could have looked in the bag, all the could have, would have, should haves, wished we had done this is not how the law works. The prosecution has to prove that there's a legal duty or that the defendants knew this would happen and failed to exercise ordinary care. They absolutely cannot reach that burden, even by the low standard required for probable cause.
Response on behalf of James Crumbley. Yes, Your Honor.
Good afternoon, Your Honor. I'm going to echo a sentiment by Sean Hopkins, Your Honor. He stated that as a school counselor, he's not a mind reader. And Your Honor, neither are parents. The prosecution, as Ms. Smith has stated, is arguing that James and Jennifer Crumbley should have known about Ethan's plans to execute the shooting at Oxford High School, or that he posed a danger to others. First, Your Honor, as Ms. Smith has stated, that is not the standard. The legal standard is not whether or not James and Jennifer should have known. The jury instruction and the law is that they actually knew. Your Honor, there has not been one witness nor one piece of evidence admitted, no piece of testimony presented to this court that indicated that James and Jennifer Crumbley knew that Ethan Crumbley was going to commit a shooting at Oxford High School on any day, including November 30th of 2021. Your Honor, using the should have standard extends this criminal liability so far beyond where we are today. It allows the prosecution to prosecute parents for the actions of their children. An example, Your Honor, 2 high school students are texting each other about having sex. One of them is under the age of consent. They carry out the act, and the parents can be charged, assuming that those text messages were sent on phones owned by the parents. 2 high school students are taking and sending nude photographs to each other, which, as this court knows, is a crime, using phones owned by their parents. Using the should have known standard, the parents can be charged for what their children did. Your Honor, the prosecution has presented witnesses who testified about what Ethan Crumbley told other people, not what he told James Crumbley. The comments that he made about his mental health deteriorating, about him asking for help from his parents, None of those messages were sent to James Crumbley, nor Jennifer Crumbley. They were sent to his friend, as the court noted. There have been no witnesses or evidence presented about a duty that James Crumbley had to any of the students who were tragically killed on November 30th of 2021. There has been no evidence or witnesses presented, Your Honor, because that duty does not exist. There is no legal duty identified by the prosecution or evidence presented or testimony obtained about a legal duty that James Crumbley owed to any of these students that were killed on November 30th of 2021. Additionally, Your Honor, there were no witnesses that testified and no evidence presented that James Crumbley knew that Ethan Crumbley was a threat to anyone, including the students of Oxford High School, or that Ethan would commit the shooting on November 30th of 2021. Your Honor, before we even get to whether or not ordinary care should have been or was used, we can't get past that in order to get to ordinary care, the prosecution has to show, even at their very low burden today, that James and Jennifer Crumbley knew. There has not been a single witness or piece of evidence presented to this court that James Crumbley knew that Ethan Crumbley was a danger to anyone other than himself. Sean Hopkins testified that he was very clear that Ethan Crumbley, that he had concerns that Ethan was a danger to himself, that he was having suicidal ideations. And Your Honor, he acknowledged that when he made James and Jennifer Crumbley aware of his concerns, they agreed to get their son counseling. The one danger that they were aware of, Your Honor, they agreed to take care to address. Unfortunately, they never got that opportunity. Your Honor, under the law, we cannot impute knowledge to James or Jennifer Crumbley without evidence that they actually had that knowledge. The prosecution can't argue that they should have known. The prosecution can't argue that there was a journal, there were text messages, there were Facebook messages, there were these things, there were those things. They can't assume and speculate that because those things existed, that James or Jennifer Crumbley did in fact have actual knowledge that their son was a danger to anyone. Without evidence that James Crumbley had actual knowledge, the prosecution is merely speculating. And Your Honor, the should have known argument that the prosecution has tried to make by saying that there were all of these things that the parents should have looked at, should have done, should have this, should have that, could have this, could have that. The prosecution is essentially conceding, Judge, that James and Jennifer Crumbley did not have actual knowledge that Ethan Crumbley was a danger to anyone other than himself, including the students at Oxford High School. Your Honor, the prosecution has not met their burden. They haven't met the low standard of probable cause. The prosecution has not even satisfied the very first element of the law in showing that James and Jennifer Crumbley had actual knowledge that their son was a danger to anyone other than himself.
Your Honor, I'm an officer of the court. And as an officer of the court, it's my responsibility to bring cases based on law, facts, and common law and statutes. So let's talk about what this case is built on, not speculation. Number one, whether or not there's a legal duty. Such a duty forming the basis for manslaughter is not a novel proposition, as it is contained in the literal handbook on criminal law in this well-respected treatise by LaFave and Scott that was published in 1973, and all of us as law students looked at this book, studied this book, and were required to know this book and what was in it. The authors discuss manslaughter based on the duty to act. In discussing duties, that it's my rebuttal. I did not object when she was talking.
The treatise is not the law.
If she would let me finish, Your Honor.
Okay.
Thank you, Your Honor.
In discussing duties that can form the basis for manslaughter charges, they state, a parent not only has a duty to act affirmatively to safeguard his children, but he also has a duty to safeguard third persons from his children. And we know Michigan recognizes this duty as noted in American States Insurance Company versus Albin, 118 Mishap 201, 1982, and Dortmund v. Lester, 380 Mish 80, 1968. It has been well settled law that there is a duty. Not once did you hear me argue or Mr. Keese argue about what the parents should have known. I didn't say it because that's not my burden. What I said was what the use of ordinary care would have uncovered. I do not have to show that they had actual knowledge that their son was going to shoot up the school. I don't have to prove that he said, I'm going to shoot up the school. I don't have to prove that he said, I'm going to go murder 4 people. I have to prove foreseeability. That's the law. And I have proven that it was foreseeable, Your Honor. And not just because of one fact, and not just because of a meeting at the school or words on a paper. So much more, and so much more than anyone else knew. No one else was in the position to know that that gun was purchased as a Christmas present, that it was accessible, that he had been disturbed, he was having hallucinations, that he was isolated, he had lost all of his friends. Nobody else knew that. Taken all together, it is absolutely foreseeable. They took a disturbed, mentally challenged, and possibly ill kid, their son, and what did they do? They didn't take him to a doctor. They didn't take him home. They didn't walk in that room and say, I love you. I'll do anything for you. What's wrong? They didn't embrace him. You know what they did? They bought him a weapon. They bought him a deadly weapon. And then at the moment when they had an opportunity in that room to say, wait, hold on a second. I'm concerned. And by the way, we know they were concerned because there was a message saying, I'm very concerned. And yet they didn't even say, we bought him a gun. And we refer to it as his gun. They can't get away from their own words. Foreseeability is what I have to prove. And when a parent learns of a school shooting, and before the shooter is ever even made public, she texts her son, don't do it. I think I've shown foreseeability, but I have a lot of other things that show foreseeability. When a parent, upon hearing that there was a school shooting, goes to his house and looks for the gun because he's worried it's his son, you didn't see any other parents do that. Why? Because he knew it was foreseeable. Your Honor, People v. Fiesel, Michigan Supreme Court from 2010 opinion. Gross negligence occurs when an individual disregards the consequences of their action or inaction while aware of the risks but are indifferent to the foreseeable result. Indifference. This perfectly describes Jennifer and James Crumbley. They were indifferent, but put another way, they just didn't care. I keep thinking about all of the things. Just one thing could have prevented this. Just one action they did. Lock the gun up, let them know he has a gun, take him home, immediately find him care. And I also keep thinking about the statements in their son's journal. If there was any question about who cared about him, it was settled on that day. Because he sat there and his parents didn't greet him or touch him or act at all concerned and said, actually, we have to go to work. We can't do this right now. I think there was no question at that point that no one cared about him. And I think that was actually the final straw for him. Judge, I've proven that the defendants are guilty of involuntary manslaughter. And I have case law, and I quoted it because I follow the law. I don't speculate. We don't bring cases against in speculation. And there's one thing I agree with. You're allowed to be a terrible parent. You are allowed to be a terrible parent. And if that's all this was, I wouldn't approve it, I wouldn't like it, but we wouldn't be here. And it's true. We don't have this charge very often in these cases. You know why? Because I'm not aware of the facts in this case ever being so egregious. It cannot be ignored. It is criminal negligence. Judge, I'm asking you to bind this case over and make and allow Jennifer and James Crumbley to stand in front of 12 of their peers, where I will then prove that beyond a reasonable doubt, they've committed involuntary manslaughter. Thank you.
The defendants in this case, that being James Crumbley and Jennifer Crumbley, are each charged with 4 counts of homicide, involuntary manslaughter, contrary to MCL 750.321. The prosecutor alleges that the defendant's 15-year-old son, Ethan, shot and killed 4 Oxford High School students with a gun that they purchased for them. Specifically, the complaint in the warrant alleges that the defendants caused the death of Madison Baldwin, Anna St. Juliana, Tate Muir, and Justin Schilling by committing the following acts or acts in a grossly negligent manner, to wit, storing his or her firearm and its ammunition so as to allow access to the firearm and ammunition by his or her minor child, or the grossly negligent failure to perform the following legal duty, to wit, failure to exercise reasonable care to control his or her minor child so as to prevent him from intentionally harming others or from conducting himself so as to create an unreasonable risk of bodily harm to others, knowing that he or she has the ability to control his or her child and knowing of the necessity and the opportunity to do so. The issue to be determined by this court is a probable cause standard. In other words, after a preliminary exam, is there probable cause to determine that a crime was committed and that the defendants committed the crime? The complaint in the warrant alleges that the defendant's behavior violated Michigan law, which provides that any person who shall commit the crime of manslaughter shall be guilty of a felony punishable by imprisonment in the state prison not more than 15 years or by a fine of not more than $7,500. Because the statute does not define manslaughter, the court must look to common law and case law for guidance. It is well established that involuntary manslaughter requires a death caused by the defendant without legal justification or excuse while the defendant was acting in a grossly negligent manner or while committing an unlawful act which was inherently dangerous to human life. That is quoted in People v. Moscow, 170 Mishap 340, a 1988 case. In 2018, the Michigan Court of Appeals addressed the common law basis for involuntary manslaughter and the threshold for gross negligence. In People v. Head, 323 Mishap 526, a father was convicted of involuntary manslaughter after his 10-year-old daughter accidentally shot and killed his 9-year-old son with a gun that the defendant stored loaded in an unlocked closet. Apparently at the time, the 10-year-old was attempting to reenact a scene from a violent video game they were allowed to play unsupervised in that same room. The court held that allowing children to play unsupervised in a bedroom in which a loaded gun was stored amounted to gross negligence on the part of the father. The Court of Appeals went on to hold that involuntary manslaughter is a catch-all crime for any homicides that do not constitute murder, voluntary manslaughter, or an otherwise justified, excusable homicide. In its opinion, the court noted that the requisites mental state for the defendant is gross negligence, which means wantonness and disregard of the consequences that may ensue. To prove gross negligence, the prosecutor must show 1, knowledge of the situation requiring the exercise of ordinary care and diligence to avert injury to another. 2, ability to avoid the resulting harm by ordinary care and diligence in the use of the means at hand. And 3, the omission or the failure to use such care and diligence to avert the threatened danger when to the ordinary mind it must be apparent that the result is likely to prove disastrous to another. It is cited in the Head case. In the Head case, the court determined that while the defendant was not personally aware that his child would accidentally shoot and kill his other child, or that he was aware that he knowingly created that possibility, The defendant did disregard the risk and the danger of 9 and 10-year-old children playing unsupervised in a room where a firearm was accessible. In fact, the court stated, quote, "It goes without saying that a loaded shotgun poses a danger to young children who are not being monitored by an adult. Defendant had the ability to avoid the harm by exercising ordinary care and diligence. By allowing his young children to play unsupervised in a room where he kept a loaded, readily accessible shotgun, defendant failed to use the requisite care and diligence. He failed to avert a threatened danger where the result was likely to prove disastrous to his children. Therefore, we conclude that there was sufficient evidence of gross negligence." That court also addressed the factual and proximate causation elements of involuntary manslaughter when it held that it was beyond question that factual causation existed. But for the defendant keeping a loaded shotgun in an unlocked closet of a bedroom where the children were playing without supervision, the shooting would not have occurred. Additionally, the court held that the child's accidental firing of the gun was reasonably foreseeable and thus proximate causation existed. Consequently, the head court affirmed the defendant's involuntary manslaughter conviction. In People v. Harris, the court stated the following: "The crime of involuntary manslaughter does not require that the defendant be personally aware of the danger or that he knowingly and consciously create the danger. The test only requires the danger to be apparent to the ordinary mind." That's 159 Mich. Ave., 401, 1987, also citing People v. Seeley, 136 Mich. Ave., 168. In Harris, the defendant was charged with murder after he confronted his daughter's ex-boyfriend with the gun, and upon racking the gun, a shot discharged, and the defendant immediately stated that he did not mean to shoot the victim. At the exam, the magistrate determined the shooting was an accident, so he dismissed the murder charge. On appeal, the court held that the magistrate abused his discretion by dismissing the case entirely because evidence presented at the exam supported a probable cause finding of involuntary manslaughter. The court relied on the OR factors, which this court previously cited, and further held that the test for involuntary manslaughter under a gross negligence theory only requires the danger to be apparent to the ordinary mind, and the killing certainly could have been avoided by exercise of ordinary care and diligence by the defendant in the use of a firearm. Therefore, in this case, after hearing extensive testimony, as well as evidence and viewing extensive exhibits, the court finds that the deaths of the 4 victims could have been avoided if James and Jennifer Crumbley exercised ordinary care and diligence in the care of their son. Specifically, the court finds that the prosecutor has shown by a probable cause standard that 1, the defendant's son, Ethan Crumbley, presented a danger to the community. Number 2, that danger was apparent to an ordinary mind. Number 3, that the defendants James and Jennifer Crumbley neglected to diligently address and or divert that danger. And number 4, that the danger resulted in the 4 deaths of the young children at Oxford High School. There was extensive testimony that Ethan Crumbley was certainly a troubled young man, and that the defendants had knowledge of that situation. But they purchased a gun which he believed was his, and that he was free to use. Therefore, the court is finding the defendants over as charged. Any argument on that?
No, Your Honor, thank you.
Yes, Your Honor. Your Honor, you've heard extensive testimony, you've seen exhibits. And although the court is finding James and Jennifer over, we are asking that the court reconsider the bond. Your Honor, Ethan Crumbley is incarcerated. James and Jennifer have given this court, they have a minimal criminal history, as we've gone over previously. We've gone through the factors with the court before. There's no substance abuse issue, there's no failure to appear issues. Judge, we're asking that you reduce the bond, allow them to be released. As the court is aware, we've had numerous issues with meeting with our clients while they're incarcerated due to COVID restrictions at the jail. It obviously impedes on their ability to meet with us, to develop their defense, Judge. So I'm asking the court to reduce their bond to $100,000, 10%.
response.
Thank you. From the people,
I'm sorry, are you having the same motion as it relates to Jennifer Crumbley?
Yes, Your Honor, I'll just, steal what Marielle says. We'll just go with that.
Thank you, Judge. From the people, there's been no changes in their status. There's no reason to amend bond. We addressed bond on January the 7th of this year. 6.106 discusses bond and conditions. This court set the bond initially upon arraignment. This court considered a number of factors, including the information contained in the swear-to, as well as their alleged flight at the time the warrant was issued. On the bond hearing, the prosecuting attorney and myself addressed the likelihood of conviction as well as other factors. The last two hearings we've had in this case have only added to that, Judge. We have provided this court with a snapshot of what the evidence will be at trial. This court has already determined that probable cause does exist as to both defendants on both theories of involuntary manslaughter. As I stated in January the 7th, these defendants will be convicted. They will go to prison. Their guidelines start at prison. We will be asking for a prison sentence, Judge. There's no reason to amend bond.
This court did hear extensive argument and testimony during the course of a bond motion that was held on January 7th, 2022. After hearing the testimony and also viewing the exhibits in this case, the court finds that there is absolutely no reason for court to change its position as it relates to bond. The court finds that in accordance with the factors set forth in MCR 6.106, that the defendants in this case are facing very serious charges, that there is a flight risk given their prior behavior, therefore the court is not going to amend the bond. It is denied that motion.
Thank you.
Thank you.
Okay, that's the argument to get to you.
Thank you, Judge.
Wow, this judge is a cunt. Like, for real. All right, let me say this. I do not agree with the judge's decision. I do agree with the bond thing. They already went out once. So, yeah, they were a flight risk. So I understand they'd probably be a flight risk again. I know I would. So I kind of agree with the fact that they're not letting them bond out. I get that. But here's where I disagree with, and maybe I missed something. I watched both days just like you guys did, okay? Yeah, this judge is an asshole. So, one thing I didn't see, maybe you guys saw it, maybe I missed it, but the one thing I did not see any proof, and I keep an open mind and think about this. I did not see any proof that the parents knew Ethan needed help. What I mean by that is, hear me out. The defense proved the case that there was no evidence that the parents knew anything. Am I missing something? Because that's what I heard. I heard all the witnesses say there was no proof that he ever told the parents anything. Other than he says he did, but there's no evidence of it. Remember, this is on evidence, not on what I think. So, but every case is different. But I have not heard any evidence that he told his parents what he told his friends. His friends never told his parents. In my opinion, they're basing this entire case on her text message to her son that said, "Don't do it," so they automatically think that she knew. So, honestly, though, if I'm missing something, tell me where I missed the evidence that he actually told his parents what was going on, not what he told his friend. Think about that for a second. Go ahead, Lindsay. Answer me. Where was that evidence? Because what I saw was quite the opposite. What I saw was them proving that there was no evidence to show that his parents knew. Well, no, Mount. It could be all the text messages, that the same things that he wrote to his friends. It could be evidence of any text message between him and the school, like lots of stuff. It's all hearsay. I did not see any proof that his family knew what was going on, other than him telling a friend, I told my parents. Okay, where's the proof? There is none. The mom could have said for not to kill himself. I absolutely agree. The text messages he sent his mom saying he was seeing me. No, I don't think he did say he sent that to his mom. Or maybe he did. I don't remember. But the police said in the 25,000 messages, other than a few, went to his parents. I mean, went to... The case will be beginning of parents being held responsible for the actions of their kids. I agree, man. I think it's all hearsay. I think both trials are going to be extremely interesting. He did through several text messages. Mom told coworkers. That's right. That's right. Do you think you would feel differently if your child was... Sarah. I'm all about giving Ethan the death penalty. I don't think the parents should be held responsible. And I know you can't give him the death penalty because he's a kid. I don't have a problem hanging Ethan. I have a problem hanging these parents. I'm not saying they aren't negligent for being bad parents. I'm not saying that they're not negligent for ignoring signs. Like, people haven't told coworkers that their kids are weird. I tell my kids are weird all the time. You know, that when I talk about that I hate circumstantial evidence, that's the kind of stuff I'm talking about. That's the kind of circumstantial evidence. The prosecution built a case making it out like these parents are Satan and making it out like they're the worst parents in the world. That's how they built this case. They failed to exercise ordinary care. Based on what, Neon? That's go a little deeper. Based on what? What proof did they fail to exercise ordinary care? Because they thought their kid was fucked up? They thought their kid was on drugs? They made some bad choices, but so do a lot of parents, and they don't end up in jail. And like I said earlier, at no point did they ever think that their kid was going to blow up a school. Just because your kid is weird doesn't make them a murderer. I think it's going to be very hard for them to prove as well. I really, truly do. No, Lindsay, it's not opposite day. I'm just saying. And people were jumping down my back in the reverse when I was on panel. It's a lose-lose. Someone will have... The parents... Not the parents. The kid will pay. There, no doubt. As he should for the rest of his life. The parents, not so much. The parents of the children he killed, they wanted his parents charged, so it's a win for Oxford. But the parents aren't a danger to society. You put people in jail because they're a danger to society. They're not a danger to society. You put people in jail to rehabilitate them. They got no more kids. They don't have to worry about any more kids. So if that was the worst thing they did, well, they don't have to worry about it anymore because the kid's in jail. How come Chris Watt's parents aren't in jail? They knew. They helped him write a letter. Why aren't his parents held responsible? Answer that one. They knew what Chris was going to do. They knew what Chris was about, and they knew about Chris's affair. So why aren't they sitting in fucking jail? Unless information was heard firsthand from Ethan's friends, it's hearsay. No, you mean right from Ethan. Parents should be watching this closely. Maybe Neon, just maybe, possibly, yeah, they didn't provide the murder weapon. I agree. His parents didn't provide a murder weapon either. I think the part, and this is just a guess, I think the part of them showing the video of him in the shooting range, meaning that he had access to the gun regardless, that counselor should be in jail as well. What, the prosecutor? Because society has finally said enough. No, they don't have other children. I mean, they do, but he's got a son, but I don't think she does. The parents are absolutely disgusting. But 3 people don't need to pay for this. Only one pulled the trigger. They purchased a gun to kill 4 children. Okay. A minor kills another child because the parents left a gun unlocked in a state that it doesn't need to be locked in. That's what people are forgetting. Michigan is a state that you don't need to keep your gun locked up. That's a major, major win for the defense. Should you keep it locked up? Yes. Is it the law? No. There's no mandatory law saying that you have to keep your gun locked up in Michigan. You like the defense said, you can't change the law. Like, the law doesn't have a precedence for this. Good luck. School, just saying if the parents go, so should, exactly. Read my response. I want to know what you say. Wait, it doesn't matter. Under the law, they are liable for his actions when it comes to a gun. No, they're not. If he takes a gun that under law, in my opinion, the judge, and this again, it's just my opinion, but in my opinion, the judge and the prosecutor are not basing this on the law. They're basing this on their feelings. I've never seen a judge give an answer that fast. She didn't even look at the evidence. She didn't even look over everything and decide like most judges do. She made a clear-cut decision initially, which she came into this case knowing. I would fucking recuse her. Did they show enough in this hearing to take them to trial? In my opinion, yes. No, I don't think so. I don't think. They saw a lot of... Because why isn't the school counselor held responsible? He saw it. He didn't even tell the parents that Ethan was a danger to others. He told the parents that Ethan is a danger to himself. Hindsight is 20/20. Exactly. Using that precedent, any DUI or car wrecks caused by anyone under 18, the parent's liability. It isn't. Exactly right. Am I held responsible for Sage's car accident because she chose to do something stupid? Is that my fault? Because I gave her the car? Car is deadlier, just as deadly as a gun. I mean, she wasn't driving drunk or anything, but... Because he is not his parents, and he did not get the gun from him. What do you mean? Does prosecution have to prove that the parents could foresee? Yes, that's kind of what the impression I got, Sarah. I'm not 100% sure, but it's kind of the impression I got. You made a clear-cut decision. No, I didn't, Lindsay. I really didn't. I'm very into innocent till proven guilty. My mind hasn't been made up yet because we haven't gone to trial yet. There's still much more evidence to come out in trial. But do I think they should be going to trial? No, not really. The school is being sued, rightfully so. But they could also sue the parents, but they're not. They're putting them behind bars. They have no access to talk to their son. They have no access to talk to him about what happened or what he feels. Nothing. They have no access. I don't know. Heather, that's a good question. I actually don't know that. They're definitely of neglect of a minor. Absolutely. They're definitely not accessory to homicide. But a danger to himself is a danger to a child. No. Most people that want to commit suicide don't blow up a school. Teachers being armed in school. I don't have a problem with teachers being armed in school. You're responsible for your child to the age of 18, especially when they cry out. But, Christy, again, I'm going to ask you the same thing I posed before. Where is the definitive proof that he reached out to his parents for help? I'm not talking a little, Mom, I'm seeing things. When I was on cocaine and I got paranoid, believe me, I told my parents I was seeing things too. They laughed at me. They, told me I needed rehab. They told me things, Granted, it was a different time, but I don't know. I would think maybe my kid was nuts. Ignore tests from Ethan about demons. Normal parent would seek help. Maybe a normal parent would seek help. How many other parents out there ignored the signs and their kids did something? I'll give you an example. My kids have never even looked at drugs. When Phoenix fainted, Dayton stood over him and said, "Dude, are you on drugs?" Why was that Dayton's first response? Well, I kind of know that answer, but in general, why was that a kid's first response? Instead of, "Mom, get up, Phoenix just passed out," which should have been a normal response. So I don't know what kind of life he grew up in. Found out and canceled my insurance. I had a great driving record. You just reminded me, I got to redo my insurance. Even if they get something for not putting the gun, but did not kill the kids. Yeah. They didn't. All right. They didn't. This is what the prosecution has to prove. They have to prove that they bought him a gun to shoot up a school. That their actions could have changed it. Well, let me tell you why that's no good and why that goes out the water. They had another gun. Ethan could have taken that gun and shot up a school. And we wouldn't be sitting here. I went back and listened to the judge. She's saying that the parents are comparable to a parent who left their 9-year-old children in a room alone with a loaded gun. Yeah, that's bullshit. That's so not true. That is not comparable at all. Chose to ignore him. Can you imagine? Maybe she wasn't near her phone, Christy. That's what I'm saying. Maybe she just wasn't near her phone. I don't stare at my phone 24/7. Yeah, Jodi Arias' parents knew she was nuts. I'm not ignoring your answer, Lindsay, because you're like one-sided. Allow is ignored something, but they better think twice or more now. So the 683,000 people that were arrested in 2019, of kids under 18, all these parents are responsible, they're going to be locking up a lot of fucking people then. If every parent should be responsible for their child. Think about it. What makes one responsible and not another one? Remember, statistics say in 2010, almost 2 million minors were arrested. So they're going to throw 2 million parents in jail? I think they do have the same judge. But the defense will rip it apart. Thank God it's a jury trial and not a fucking judge. How is the prosecutor supposed to prove that he told his parents about problems in person? Well, Lindsay, I can reverse that. How is the defense supposed to show that Jennifer didn't speak to her son? That Jennifer didn't ask her son for help, or that Jennifer didn't call somewhere? It's the same thing. Parents should not be responsible for what their kids do. But in this case, I think they should hold some type of... Exactly. Some type of responsibility. Absolutely. Not negligent homicide. Oh, it's a bench trial? Oh, fuck that. They have every right to ask for a jury trial. They need a jury trial, not this judge. Yeah, I read it last night. In 2019... 683 minors under the age of 18 were arrested and charged. Like 863 of them were murder. So they're going to lock up all those parents? Because if you're saying that parents are responsible, what about minors that get killed? By cops. Are those parents responsible? Maybe he asked for help, prove he didn't ask. There's no proof of it, Rainey. But that's what I'm saying. You can't put away somebody for negligent homicide based on hearsay. That's what we keep saying. That's fucking hearsay. Okay, so it is a jury trial. Yeah, I was going to say. Oh, I was saying no. No, it wouldn't be a bench trial. Everybody wants a jury trial. Did all those parents make the guns easily accessible? I don't know. That I don't know. But even if they didn't, where do you draw the line over... Where do you draw the line over who's responsible, what causes responsibility? Because they bought their kid a gun because they were into guns, and somebody said it before. Maybe, just maybe, they actually thought that this was something they could do together. Maybe they thought this would help their son. I don't know. People that are into guns would say that they did the right thing. No, yes, 683,000 minors were arrested for violent charges in 2019. They will definitely get the book thrown at them if they ask for a jury. No, they will ask for a jury trial. See, I agree, Christy. When did they change the gun laws? On the day Jen had to call and reschedule horse lessons, but did not call set up counseling. Yeah, but we don't know that, guys. We have not heard evidence. We have only heard bits and pieces of evidence. And that goes on both sides. Yeah, the judge, I don't like this judge. You literally had a panel of gun owners on your channel. Before that, all agreed the parents should be liable. I didn't... What all gun owners say the parents should be liable? They should be liable for something, not for homicide. Nikki, I agree with you on that. But gun owners will tell you differently. Gun, yeah. Oh, I don't know. I don't know about that, Lindsay. Shotgun, handgun, to me, they're all the same. Yeah, Whistledown took her kid. Whistledown's husband took his daughters are very young and know how to shoot. I own loads of guns. I don't believe they should be liable for anything. Thank you, Jay. Something but not killing. Exactly. I'm telling you, this has turned into a fucking gun issue law. I guarantee this judge is a Democrat. I would absolutely guarantee it. She is a Democrat. This is now being made an example of gun laws. I think anyone, including a child, who can pass a shooting test. We own guns too, and I feel they should be liable. They had knowledge of his MH issues. The school had knowledge. No one even checked his backpack that very morning. Parents didn't take him home. He stayed and killed. But yet, there's only 3 people behind bars. Giving a child gun with depression, except maybe they thought it would cheer him up. Oh, that's the, whatchamacallit? That's the screen. We'll just be candles. There you go. Nice, clean candles. Am I blocked? No, not yet. But I am getting off in a minute. My comment didn't show up earlier. I don't know why. No, Felicia, I'm not saying Democrats don't own guns. I'm just saying that, you know, there's a lot more to it. No, it wasn't me. And by the way, this video behind me is not mine. My candles don't dance that much. This isn't political. Lindsay, everything is political, Lindsay. Everything. Maybe they... Okay, again, we don't know the full evidence. Maybe they didn't. Is it possible that they didn't? But Star, again, the last page of his journal said, I have to find the gun. Thank you. Thank you, VZ. That's what I'm saying. There's a lot of evidence, guys, that people are not listening. They didn't buy him a gun. He claims they bought him a gun, and mom was trying to sound cool on social media. It wasn't his gun to keep. This case is not as specific as you guys think it is. Believe me, it's political. There's a lot of shit that has gone on in Michigan. It is political. The questions we're asking will be answered in a trial that I'm glad we'll see happen. I don't know, Glancy. I just don't think the parents should be charged with murder. Other things they could be charged with, I'm okay. I'm okay with them charging them with neglect and a lot of things. Not murder. They just don't fit the murder. The gun was in the gun safe with a 000 combination, easy to find. The gun should have been locked up. But do they deserve this charge? I'm torn. In order for them to prove gun laws, that's how karma, gun laws. In order for them to prove the parents were liable, okay? In order for them to prove it, they have to prove that they bought him a gun to go shoot up people. That's what they have to prove. The prosecution can't prove that. They go to a jury trial next, yes. And they can't prove that they bought him a gun to shoot up a school. I believe both prosecution and sheriff are up for voting 2022. It's political. Thank you, Christy. It is political, so they can manipulate it and take away our weapons. Damn right. I will admit for me, it is a complicated case, Amanda. But again, we haven't heard all the evidence. The only evidence we heard is very few. Is very little. That's okay, Pop Not Soda. You could totally disagree with me. It's what makes the world go round. No, that's what the defense was saying. That's pretty much what the defense was saying. But I will say this, as long as they keep the same attorneys, I could listen to their attorneys talk in court. Some attorneys bore me to death. They're actually pretty interesting. Just like they did in England with the Dumley Massacre. They banned handguns for law-abiding citizens when the shooting was done illegally. Yeah, the reason why they can't get rid of guns totally, because you can't. Criminals will still get guns. You have to be able to defend yourself, especially in today's day and age. Because I heard that a lot of parents at Oxford want gun control. And they want gun control, and the students want gun control, but I would think the opposite. I would think they'd want a gun just in case something like this ever happened again. They could protect themselves. Shit, I'd carry a gun all the time. So I go, actually, we don't always agree. Today we do. There you go. I don't want your weapons. I just want you to have them if you are, not have them if you are irresponsible and selfish. I agree with that. Because you can't say what you think and you don't. Nah, I don't block. I only block if you're an idiot. Michigan, can a person who has mental issues buy a gun? Yeah, but Kat, the problem is there was no actual proof that he had mental issues. I mean, you heard... All right, let me ask you guys a question, and then I got to get off because I really need to get work done. But let me ask you guys a question. So I have rope in my garage, and I have a stool, okay? But I got plenty of rope in the garage. I got straps. I got a noose. Not a noose, but I got rope to make a noose. So if one of my kids... All right, let me back up. If I asked one of my kids to help me build something with the rope and gave him the rope, and then 2 days later he hung himself, is that my fault? Because we had rope in the garage? That I told him where to get the rope? Think about it. Like, seriously, think about that. That's what they're telling the parents. Oh, Karma, we know he had mental issues, but I'm saying hindsight's 20/20. So the reason I'm even thinking of that is the counselor said that three people this year have tried to commit suicide or attempted suicide from that school, kids that he saw. So why aren't those parents held responsible? Rope is a weapon if you want it to be. Shit, a pencil's a weapon if you want it to be. I bet some of the people they're sitting in jail with should have been in jail 20 years ago because of how they raised their kids. Think about it. No, pop, not soda. And it is soda, not pop. But what I'm saying that for is what the counselor said. The counselor had said that you get 3 kids try to commit suicide. So where are their parents? Thank you, Kimberly. Evidently, if you know your child is. We haven't heard a lot of the evidence. A gun isn't made specifically for killing either. I mean, in a way it is, but it's not. You would have a hard time going through into a school and killing 4 people with a rope. No, I was talking about the suicide. I was talking about that the counselor didn't say he was going to hurt somebody else. The counselor said he was going to hurt himself. That's what the counselor said. He was going to hurt himself. And the parents felt like he wasn't going to hurt himself. They certainly didn't think he was going to shoot up a school. So then every single parent is liable for the actions of their kids. You can't pick and choose which case parents are liable for. I'm not oversimplifying it. At this point, I don't think that there's enough to hold them. I don't. But I haven't heard all the evidence. I already covered that. You don't know what the mom was thinking. If maybe she's the sole breadwinner. He was a driver for Uber. He didn't make that much money. You still got bills to pay. And that's circumstantial. You don't know her frame of mind at the time. You don't know what she was thinking. I know you can run with the obvious, like, what a fucking stupid thing. But not if she's thinking about, oh my God, I got bills to pay. Like, in today's time, I can't be without a job. Like, I got past COVID, I got this, this pays all that. We don't know. A gun is used to look pretty. A gun is there to protect you. People don't buy guns thinking I'm going to have to use it. You try not to use it. Oh, I know the parents suck, Karma. I'm not saying they don't, but I don't think they should get negligent homicide or involuntary manslaughter. How many purposes does a rope have? I'm just saying. Shooting targets like archery, it's a sport. There you go. So the school counselor should be arrested for not reporting. Exactly right. He didn't even see that the kid needed help. He thought that the kid needed help to not harm himself, not that he was going to harm someone else. The parents were not warned that he was going to harm someone else. The parents felt like he was probably best off at school than he was at home. I'm telling you, you guys are going to see all of this in trial. You'll see. You'll see. You're going to say, wow, Laura was right. This is the shit that the defense is going to use. Guaranteed. And the jury will be interesting. Manatee County Recorder, huh? You can when it states that you are if they harm someone with a gun. Okay, so then every single parent should go to jail. Are they now going to arrest all the other school shooters' parents? It's the same situation, except for one, I believe, was older. Let's go back to Columbine and arrest their parents. They needed mental help. They got the same. Let's go arrest them. There's no statute of limitations on murder. So let's go back and arrest Colbert's parents. Colbolt, whatever his name was. let's go arrest them. Same thing. Have I checked into my ventilation? Why? Because you think my brain is losing it? I'm serious. Watch. Just watch. Everything I'm saying is going to come out in trial. Guaranteed. Guaranteed. Mark my words. But I do believe they are a flight risk. I think they would run. They would somehow try to run. But I don't think they're a threat to society that they couldn't be let out. They could have given them ankle bracelets and confined them to their house. I don't think they need to sit in jail through trial. I think it's wrong. They never cried out for help like he did. So, all right, but I got to get off. I'm like 2 days behind. I got to get candles out, labels done. But I will see you guys later or tomorrow. I knew what you meant, Pop. I will see you guys later or tomorrow. I don't know if I'll be on later. It depends how much I get done. And that's it. So I will see you guys later or tomorrow. It was interesting, and it was wonderful spending the last 2 days with you guys. I will see you guys later. Thank you so much for the super chat. Thank you for the member. Would I feel differently if this happened in your community? I'm very all about, I'm going to say this again, I'm all about the kid going to jail for the rest of his life. I'm all about Ethan taking responsibility for this and stop putting it off on everyone else. I still don't think the parents deserve to be in jail for homicide or involuntary manslaughter. I don't think that's the proper charge. Put them in jail for negligence. Put them in jail for something. But to keep them locked up while awaiting trial, even though they are flight risks, there are things you could do around that. But to put them like they actually did something is not how the law works. That's not the kind of law. Justice, they're not serving them justice by keeping them locked up when they actually didn't even do anything. That's ridiculous. So, that's just that. All right, I will see you guys later. Have a wonderful day. Love you too. And don't forget, hit that like and subscribe. And know that when you come here, you can have a difference of opinion. Lindsay is a surefire Spitfire for that one. All right. I will see you guys later. I think if you knew your child had mental health problems, you'd hide the rope. If you gave him the rope, then your own guilt. If he told you he wanted to kill someone with rope, then did it, yep. All right. That's the problem. They didn't do anything.